Moment to get the computer going and turn on the feeds. Okay, this is case number 2018 CA 5321. Jack Kowalski, etc., et al. Versus Johns Hopkins All Children's Hospital. I've been handed a note from the jury that reads as follows. We have reached a verdict. Do the attorneys wish to look at the note?
Not on behalf of plaintiff.
Okay, I'm going to go ahead and file that with the clerk. Are there any issues we need to address before we bring in the jury?
Not on behalf of plaintiff, Your Honor.
Not from the defense. That's your honor.
Do the parties need any moments to talk with each other before we bring them back?
I don't think so, Judge.
No, Your Honor.
Okay. For the folks here in the courtroom, I would ask that as this verdict is read, it's going to take a while to read the verdict, but as the verdict is read, I would ask that we not have any sort of audible or visual reaction. So please keep your emotions in check. At this point, let's bring in this jury.
All rise. Jurors enter.
Okay, please be seated. Okay, members of the jury, welcome back. I have been told, or I've received a note from you that you have reached a verdict. Is that correct?
Yes.
Can the foreperson hand the verdict form to the court deputy who will bring it to me? You're going to ask the clerk to publish the verdict, please.
In the 12th Judicial Circuit in and for Sarasota County, Florida, case number 2018 CA 005321NC. Jack Kowalski, individually, Jack Kowalski as parent and next friend of MK, a minor, and Jack Kowalski as personal representative of the estate of Beata Kowalski, plaintiffs, versus Johns Hopkins All Children's Hospital, Incorporated, defendant. Verdict form. We, the jury, return the following verdict. Claim 1, false imprisonment, October 7th through October 13th, 2016, Maya Kowalski. 1. Did Johns Hopkins All Children's Hospital falsely imprison Maya Kowalski without legal authority under circumstances that were unreasonable and unwarranted between October 7th and October 13th, 2016? Yes. 2. What is the total amount of Maya Kowalski's damages for the medical and psychological expenses to be incurred in the future after she reaches the age of 18 based on the false imprisonment occurring between October 7th and October 13th, 2016? $2,496,000. 3. What is the total amount of Maya Kowalski's damages for pain and suffering, mental anguish, inconvenience, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future based on the false imprisonment occurring between October 7th and October 13th, 2016. $3 million. 4, what is the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably obtained by Jack Kowalski for his child, Maya Kowalski, in the past or to be so obtained in the future until Maya Kowalski reaches the age of 18, based on the false imprisonment occurring between October 7th and October 13th, 2016. $67,200. 5, under the circumstances of this case, state whether you find by clear and convincing evidence that punitive damages are warranted for the false imprisonment occurring between October 7th and October 13th, 2016. Yes. Claim 1, false imprisonment, October 18th through October 20th, 2016, Maya Kowalski. 6, the Johns Hopkins All Children's Hospital falsely imprisoned Maya Kowalski without legal authority under circumstances that were unreasonable and unwarranted between October 18th and October 20th, 2016? Yes. 7, what was the total amount of Maya Kowalski's damages for medical and psychological expenses to be incurred in the future after she reaches the age of 18, based on the false imprisonment occurring between October 18th and October 20th, 2016? $1,400,000. 8, what is the total amount of Maya Kowalski's damages for pain and suffering, mental anguish, inconvenience, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future based on the false imprisonment occurring between October 18th and October 20th, 2016? $3 million. 9, what is the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably obtained by Jack Kowalski for his child, Maya Kowalski, in the past or to be so obtained in the future until Maya Kowalski reaches the age of 18, based on the false imprisonment occurring between October 18th and October 20th, 2016? $561,298. 10, under the circumstances of this case, state whether you find by clear and convincing evidence that punitive damages are warranted for the false imprisonment occurring between October 18th and October 20th, 2016. Yes. Claim 1, false imprisonment, January 6th, 2017, Maya Kowalski. 11, did Johns Hopkins All Children's Hospital falsely imprison Maya Kowalski without legal authority under circumstances that were unreasonable and unwarranted on January 6, 2017? Yes. 12, what is the total amount of Maya Kowalski's damages for medical and psychological expenses to be incurred in the future after she reaches the age of 18, based on the false imprisonment occurring on January 6, 2017? $188,000. 13, what is the total amount of Maya Kowalski's damages for pain and suffering, mental anguish, inconvenience, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future, based on the false imprisonment occurring on January 6, 2017? $15 million. 14, what is the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably obtained by Jack Kowalski for his child, Maya Kowalski, in the past or to be so obtained in the future until Maya Kowalski reaches the age of 18, based on the false imprisonment occurring on January 6, 2017? $325,000. 15, under the circumstances of this case, state whether you find by clear and convincing evidence that punitive damages are warranted for the false imprisonment occurring on January 6, 2017? Yes. Claim 2, battery, January 6, 2017, Maya Kowalski. 16, did Catherine Beatty and any bedside nurse commit a battery on Maya Kowalski on January 6, 2017? Yes. 17, what is the total amount of Maya Kowalski's damages for psychological treatment incurred in the future after she reaches the age of 18 based on the battery occurring on January 6, 2017? $4 million. 18, what is the total amount of Maya Kowalski's damages for pain and suffering, disability, physical impairment, mental anguish, inconvenience, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future based on the battery occurring on January 6, 2017? $8 million. 19. What is the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably obtained by Jack Kowalski for his child, Maya Kowalski, in the past or to be so obtained in the future until Maya Kowalski reaches the age of 18 based on the battery occurring on January 6, 2017? $559,000. 20. Under the circumstances of this case, state whether you find by clear and convincing evidence that punitive damages are warranted for the battery occurring on January 6, 2017. Yes. Claim 2, battery, hugs, pats, kisses, and placing on lap, Maya Kowalski. 21. Did Catherine Beatty commit one or more batteries on Maya Kowalski through hugging, patting, kissing, and placing Maya Kowalski on her lap? Yes. 22. What is the total amount of Maya Kowalski's damages for psychological treatment incurred in the future after she reaches the age of 18 based on Catherine Beatty's hugging, patting, kissing, and placing Maya Kowalski on her lap? $8 million. 23. What is the total amount of Maya Kowalski's damages for pain and suffering, disability, physical impairment, mental anguish, inconvenience, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future based on Catherine Beatty's hugging, patting, kissing, and placing Maya Kowalski on her lap? $11 million. 24. What is the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably obtained by Jack Kowalski for his child, Maya Kowalski, in the past or to be so obtained in the future until Maya Kowalski reaches the age of 18 based on Catherine Beatty's hugging, patting, kissing, and placing Maya Kowalski on her lap? $1,000. Claim 3, medical negligence, Maya Kowalski. 25. Was Dr. Sally Smith an apparent agent of Johns Hopkins All Children's Hospital at the time and place of any treatment she provided to Maya Kowalski? Yes. 26. Was Dr. Sally Smith negligent in the medical care of Maya Kowalski? And was that negligence a legal cause of loss, injury, or damage to Maya Kowalski? Yes. 27. Excluding and not considering the conduct of Dr. Sally Smith, were one or more healthcare providers negligent in the medical care of Maya Kowalski at Johns Hopkins All Children's Hospital? And was their negligence a legal cause of loss, injury, or damage to Maya Kowalski? Yes. 28. What is the total amount of Maya Kowalski's damages for lost earnings in the past, loss of earning capacity in the future, medical, psychological, and nursing care and treatment expenses to be incurred in the future? $4,700,000. 29. What is the total amount of Maya Kowalski's damages for pain and suffering, disability or physical impairment, mental anguish, inconvenience, aggravation of a disease or physical defect, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future? $22 million. Claim 4, fraudulent billing for Mr. Kowalski. 30, did All Children's Hospital fraudulently misrepresent a material matter in its invoices to Jack Kowalski or his insurers? Yes. 31, did Jack Kowalski or his insurance company rely to their detriment on the fraudulent misrepresentation you found in answer to question 30? Yes. 32. What is the total amount of Jack Kowalski's damages for any deductibles or co-pays incurred as a result of Maya Kowalski's sheltering at Johns Hopkins, or increases in the cost of insurance coverage in the past or in the future, including increased premiums, co-pays, and higher deductibles? $3 million. 33. What is the total amount of Jack Kowalski's damages for the difficulty of finding insurance in the future? $2 million. Claim 5. Survivor claim for the intentional infliction of emotional distress in the estate of Beata Kowalski. 34. Did Johns Hopkins All Children's Hospital, through the acts of its employees, engage in extreme and outrageous conduct, intending that conduct to cause or with reckless disregard of the high probability of causing severe emotional distress to Beata Kowalski prior to her death? Yes. 35. What is the total amount of Beata Kowalski's damages for pain and suffering or mental anguish caused by the extreme emotional distress prior to her death on January 7, 2017? $3 million. Claim 6. Wrongful death claim for intentional infliction of emotional distress causing death in the estate of Beata Kowalski. 36. Did Johns Hopkins All Children's Hospital, through the acts of its employees, engage in extreme and outrageous conduct, intending that conduct to cause or with reckless disregard of the high probability of causing severe emotional distress to Beata Kowalski that was sufficient to be a legal cause of Beata Kowalski's death by suicide? Yes. 37. Did the conduct that you found in question 36 create in Beata Kowalski an uncontrollable impulse to die by suicide? Yes. 38. Was the conduct that you found in question 36 a substantial factor in Beata Kowalski's death by suicide? Yes. Question 39 addresses damages of the estate. What is the total amount of any damages sustained by the estate for loss of net accumulations? $653,676. Question 40 and 41 address damages of surviving spouse Jack Kowalski. 40. What is the amount of any damages sustained by Jack Kowalski for the loss of Beata Kowalski's support and services and funeral expenses resulting from Beata Kowalski's death paid by Jack Kowalski? $18 million. 41. What is the total amount of damages sustained by Jack Kowalski for the loss of his wife's companionship and protection and for his pain and suffering as a result of Beata Kowalski's death? $50 million. Number 42. What is the total amount of damages sustained by Maya Kowalski for the loss of Beata Kowalski's support and services? $2 million. 43. What is the total amount of damages sustained by Maya Kowalski for the loss of parental companionship, instruction and guidance, and Maya Kowalski's pain and suffering as a result of Beata Kowalski's injury and death? $18 million. Question 44 and 45 address the survivor damages of Kyle Kowalski. 44. What is the total amount of damages sustained by Kyle Kowalski for the loss of Beata Kowalski's support and services? $2 million. 45. What is the total amount of damages sustained by Kyle Kowalski for the loss of parental companionship, instruction, and guidance, and Kyle Kowalski's pain and suffering as a result of Beata Kowalski's injury and death? $18 million. Claim 7, intentional infliction of emotional distress, Maya Kowalski. 46, did Johns Hopkins All Children's Hospital, through the acts of its employees, engage in extreme and outrageous conduct, intending that conduct to cause or with reckless disregard of the high probability of causing severe emotional distress to Maya Kowalski? Yes. 47, what is the total amount of Maya Kowalski's damages for lost earnings in the past, loss of earning capacity in the future, medical expenses incurred in the past, and medical expenses to be incurred in the future? $3 million. 48. What is the total amount of Maya Kowalski's damages for pain and suffering, disability or physical impairment, mental anguish, inconvenience, aggravation of a disease or physical defect, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future? $7,500,000. So say we all, this 9th day of November 2023, four-person.
Hand me back the verdict form, please. Do the attorneys wish to inspect the verdict form?
Yes.
Please come. Oh, counsel, please come forward if you wish to inspect the verdict form. Mr. Anderson, did you also want to see it?
I look over the shoulder.
Thank you. Does either the plaintiffs or the defense wish to poll the jury?
Yes, sir, Your Honor.
Madam Clerk, please poll the jury. And use juror numbers as opposed to names.
Juror number 1, is this your verdict?
Yes, it is.
Juror number 17, is this your verdict?
Yes.
Juror number 19, is this your verdict?
Yes, it is.
Juror number 93, is this your verdict?
Yes, it is.
Juror number 97, is this your verdict?
Yes, it is.
And juror number 98, is this your verdict?
Yes, it is.
May I see the attorneys up here for just a moment, please? Step back, please. Okay, members of the jury, your service is not yet complete based on the questions that you answered. We're going to move into phase 2 of this case. My goal is to try to start phase 2 about 2:30 this afternoon. So I'm going to give you all a few minutes to go stretch your legs. You cannot discuss this case further amongst yourselves. You cannot get any further information, and you cannot do any research. Do not review any media accounts of this case. Do not let anyone approach you about this case. Do we all understand that?
Yes.
Okay, and have them back at 2:30.
Yes, sir. All rise. Jurors exit stick.
Okay, everyone, please be seated. The jury is out. I'm going to hand the verdict form back to the clerk. I'm going to ask that you process it and publish it to the court docket as soon as possible. We're going to take a break until 2 p.m. At 2 p.m., we're going to come back and work on the punitive damage, jury instructions, and verdict form. And I see Ms. Ferrier's on by Zoom. I see Mr. Altenburns here. I guess at approximately 12:45, the court circulated another version of the punitive verdict form and jury instructions, and we'll work off of those documents. I'll see everybody back at 2 p.m.
All rise. Court is in recess.
because his equipment is gone, so I'm just gonna hook in through the court system, like we did, the other day.
But then the TV folks won't be able to pull it off on the TV.
I could communicate with them and see if they have a switch and I could patch into it, but I think that they could push into one of the big gallery monitors if they need to see any visuals.
Well, you can set that up, but I'm going to go ahead and proceed. We're now going to turn our attention. Let's see, Mr. Hunter's coming back in. Mr. Altenburg's already here. Actually, I need the plaintiff's lawyers. I mean, Miss Lawrence is here. There's Mr. Whitney.
It's okay. Ms. Lawrence had it in her hand. It was well handled by her. She's grabbing Mr. Anderson.
And I do have Mr. Elliott by Zoom. Let's talk about the proposed instructions. And Mr. Elliott, are you finished with your oral argument at the District Court of Appeal?
Yes, Your Honor, and I'm back in Tampa, although I'm having some computer problems, so I'm still on my phone.
Oops, I probably was on the wrong setting, Mr. Reyes. I'm just trying to get everything up so that the TV folks can see you, Mr. Elliott.
No, that's fine. Could you hear what I am back in Tampa?
You're back in Tampa. I heard that. Have you received the draft verdict form and draft jury instructions that were circulated approximately 12:45 today?
I have received them, but I can't access them right now because of having a computer problem. But I think it was what we looked at before with just adding that other question in, wasn't it?
Well, I added a little extra language.
Oh, okay. I saw that you had sent something.
Is there someone in your office that can print it out or somehow bring it?
That's a good idea.
Or bring you a device?
Oh, wait. Here, I think I'm. Okay. Oh, I'm back in. Okay, hold on. Let's see. Let me open your draft. We're talking about the verdict form right now.
We probably should start with the instructions and then go to the verdict form.
Okay. I'm opening those now. Okay.
Yes. I mean, I just wanted to let the TV folks have access to the feed if they were so inclined.
I see the alternate between clear and convincing or greater weight. Are there then questions that match up on the verdict form to that?
Yes.
Okay.
Mr. Altenburg, do you have?
I have this open on my phone. I am not. This came in about the same time I started traveling. So.
Do you want me to? I can just print out another copy and I can give.
I understand what you did, and and first let me object as vigorously as I can to the fact that we are now having the jury answer a phase one question by clear and convincing evidence that I had no notice of until this morning. We didn't have a chance to defend against it. We've had no chance to argue against it. It should have been in the phase one instructions, and now you're going to intermingle the phase one and phase two instructions when we wanted a bifurcated proceeding. So I object vigorously to this second question being on this form.
Doesn't the standard jury instruction have this in a phase two?
No, there is no standard jury instruction whatsoever on the specific intent question. And the only case that I can find, and I think that Mr. Elliott has found, is a case that put it in the phase one instructions.
Mr. Elliott, anything you'd like to say?
All right. I don't have a case in front of me. That's the Longwood case.
I
don't think it says it, isn't it?
It's the Longwood case. It doesn't discuss it, but footnote 10 quotes the instruction, and that instruction was given in phase one because it's not an instruction on damages. It's an instruction on the substantive elements that are going towards punitive damages, and that has to be tried during the case and presented in phase one, not in phase two.
Mr. Elliott, any response?
Your Honor, I think it can, they're going to answer it now. I don't read law good to say that's where it has to go. That's just the way it was done there, and there is not a lot of law. So I assume they want that asked, and it should be asked here.
It's a due process manner. We were entitled to notice of this and the opportunity to defend it and to have it on the first verdict form.
Well, here's what we're going to do. I'm going to allow the question to go, especially since, when I say go, it'll go to the jury, especially since Section 768.73 prohibits us from telling them why we're asking them the question, which is basically whether or not the punitive damage cap applies or can be avoided. And since we don't tell them why we're asking them the question, I don't see, it's the same evidence between phase one and phase two. There's a little extra evidence in phase two, so I'm not exactly sure why it would matter, but I recognize the objection.
Are we going to be allowed to put on the evidence we need for that question?
You're going to be able to put the evidence that you wish to put on. Mr. Cottrell is coming back, I see.
But to be clear, we were not preparing anything to put on for this particular issue until we received notice this morning that they wanted to do it this way.
Well,
So we're having a trial with, 4 hours notice or something like that on an issue that should have been tried throughout the trial from the very beginning.
I understand your objection, and this is how we're going to proceed.
Okay?
And to be as clear as I can, Mr. Altenburn has preserved this issue for appellate purposes, and if we need to address it in post-trial motions, we can definitely readdress it then. But I'm going to get the finding from the jury as to what they are thinking. So, with respect to the instructions, Mr. Altenburn had a slight change to go to when you determine. Any problem with that, Mr. Elliott? On the second line?
Let me get back to them. I'm sorry, Ron. I flipped over to the verdict form. Let's see. Well, if you could read it to me, I probably don't. I'm just having trouble calling it up here.
Well, currently it reads, members of the jury, I am now going to tell you about the rules of law that apply to determining whether, and Mr. Altenburn suggested, tell you about the rules of law when you determine whether.
Oh, that's fine. That's fine.
That apply when you determine whether.
That apply, yeah, absolutely. I apologize for not saying that word. I'm just going to make the change here so I don't forget it. Okay. The next is at the end of that paragraph where it talks about should decide any disputed factual issues. What it currently talks about by the greater weight of the evidence, I added or by clear and convincing evidence as specifically indicated on the verdict form. So it will reference both standards and then define both greater weight of the evidence and clear and convincing evidence. That's my recommendation.
And I think that is consistent with our effort to have questions that will answer this one way or the other, depending on legal rulings later.
Mr. Altenburn.
Well,
Knowing
my prior objections that have been overruled, I guess that goes with what you want to do, so I can't stop it.
Right. And again, I know you are objecting to having the specific intent question on the verdict form.
Yes. And anything and everything that relates to it, yes.
And I also know that you are suggesting that the specific intent has to be a clear and convincing evidence finding. And I'm actually leaning in your camp on that but that's why I didn't quite know, because the case law doesn't really say whether it is clear and convincing or greater weight.
There's very little case law, but it lines up as a finding on something that is a predicate to being entitled to damages, which means it's a finding of fact on a substantive matter for which clear and convincing evidence was necessary during the trial and during the first verdict.
So I will add the language that I proposed on page 1. Now, Mr. Altenburn, on page, I guess it's technically page 3, A, 1, 2, and 3, you had some comments.
And I've taken those out. That's all right.
Okay, so is the language okay as it's circulated, where one has whether the wrongful conduct was motivated solely by unreasonable financial gain?
Yes.
And so we're leaving that in?
Right. I mean, I believe there's no evidence of that, but I think they have to know that they're supposed to have that to do this. So, yes.
And I haven't had a chance to talk to the trial team on that. I guess I would ask Nick or whoever's there. I mean, if we want that in.
We need the question.
Okay.
Well, no, hang on, no. I didn't mean it that way. We're wondering what the question is.
Well, the question is, does A1, whether the wrongful conduct was motivated solely by unreasonable financial gain, should that be a question, an instruction in the verdict form, in the instructions, and then I assume there's a question on the verdict form that corresponds.
There is not a question on the verdict form.
Understand why we would need that.
Yeah, I don't think that's the contention. So I think maybe one can come out, A1 can come out.
Yeah, I think we're talking about, I confess to being a bit behind schedule here on where we're going to insert such a thing.
Mr. Altenburn is suggesting that number 1, which would require the wrongful conduct was motivated solely by unreasonable financial gain, that isn't something that we need to instruct on because that wasn't the theme of the case.
Agreed.
But let me check with my trial counsel because they didn't prove it. It's not an issue. And if that's normally a factor, we ought to be able to point out that's not why we did it. So I don't know how you want to argue.
I think it's a factor in the sense of it's another cap alternative that we're not asserting.
Yeah, but for some strange reason, it's in the standard form as if you give it every time. And so, I mean, I don't think there's proof of issue 1 or issue 2 on that form, which is why I question whether they should be there. Let me, if you don't mind, can I?
No, you can ask, absolutely. Would it help if I just had my assistant print out a couple paper copies?
That would help the trial team tremendously.
Yeah, I see it is in, I do see that it's in C2 subpart A, but I think, let's see if there's an instruction.
There's no proof of D1 or D1 not. That's the question. And then whether the unreasonable dangerous conduct.
Okay, Your Honor, I'm looking at the note on page, it's note 5. In the printed version, I guess that doesn't matter, but it says instruction 503.1C2. I'm looking at the right thing.
Your Honor, right now, we don't know whether you're allowing opening statements or arguments.
Sure, you get opening statement.
We'd like to leave it in.
Okay. So, Ms. Syback, go ahead and print what I just forwarded you, 4 copies, please, and bring it in. Okay, well, I'll go ahead and leave it in right this second. I then added, you may, in your discretion, decline to assess punitive damages. That seemed to be as a standard that the prior version didn't have.
That's right. that was, it's supposed to have been in there, and it just wasn't put in there for some reason. That's in the
So,
standard.
so you're okay with me adding that
Yes,
sentence?
I had added precisely the same language in what I said.
And
And yes, plaintiffs are okay too, Judge, that is in the standards.
I think that was the balance of the issues in the instructions. Let's go over to the verdict form. And then hopefully my assistant will bring this in just a moment. Do you have the verdict form there, Mr. Elegant?
I do, Your Honor, thank you.
Mr. Altenberg, do you want me to proceed or wait for the printed paper to come out?
I'm able to read this fine.
I'm sorry, are you going to read it fine? Okay, so from a conceptual basis, what I did is the question number one is the damage question. And I think that comes from the standard, and I don't think there's any objection to that. And then following the damage question, there are two additional questions, which is the specific intent question. The first specific intent question would be to the clear and convincing evidence, and then if they answer no to that, then it directs them to go to the greater weight. So we would know by what quantum if the jury were to conclude that there was a specific intent of harm. Now, I know this is over the defense's objection, and they don't want it, and I'm saying we're going to have it. So under those circumstances, Mr. Altenburn.
Given your prior rulings, this is consistent with your prior rulings.
But how it's framed, doing the clear and convincing evidence standard, and then going to the greater weight.
If it's on this form, that's how you have to do it.
Mr. Elegant.
Agreed, Your Honor.
Are there other matters within the verdict form that we need to address?
Yes, Your Honor, and it actually impacts the jury instructions as well, now that I'm looking at it. We had discussed combining January 6th into one. Somewhat, I guess since I'm objecting to this, the clear and convincing part of this, it might as well be combined for the two of them. It's easier to combine the two of them than it is to try to explain non-duplication to a jury that hasn't been avoiding non-duplication in the first half of this. So I just assume have them combined by you.
So what
I would take issue with that, but.
Well, Mr. Elegant, the concept here is
No, I understand.
for the photography session, just combine the false imprisonment and battery.
I would turn to my trial counsel and ask if I have a chance to talk with them, ask if they're okay with that. I mean, I see the logical sense, and it's the same with that.
Just define the questions.
The two January 6th, yes.
Yes.
Okay.
All right.
That sounds good, and then we avoid the non-duplication that you're identifying. My comment before was I wasn't agreeing that the jury had disregarded anything as far as the duplication goes.
Okay, so what question 7 will read, at the top it says Claim 1C and Claim 2, false imprisonment and battery, January 6, 2017. Question 7, what is the total amount of punitive damages, if any, which you find by the greater weight of the evidence should be assessed against Johns Hopkins All Children's Hospital for the false imprisonment and battery of Maya Kowalski occurring on January 6, 2017.
I think that's a correct combination.
Agreed.
And so that means the verdict form will only go to question 9. So I got to change the instruction.
And then questions 8 and 9 would need to be modified slightly too.
And I am doing that as we speak.
I thought you might.
And in a few minutes, what I will do is I will recirculate the final version, and please check all of my cross references. And make sure when I consolidated the false imprisonment and battery for the photo session that I didn't mess it up. So this will be on page 7. Okay, now Mr. Altenburg, you said that there needs to be a change to the jury instructions as well?
I
changed the
we
verdict form.
combined it so we don't need a non-duplication in the jury instruction.
Now, knowing, Mr. Altenburg, knowing that I am going to allow the specific intent questions, and I know you object, and I know you've preserved that, and
I don't believe I have any other objections to the form.
okay, that's my question is there any other change to the language other than the fact that we are going to have the specific intent questions?
No, Your Honor.
Okay. Mr. Elegant, any others?
No, Your Honor.
Okay, so what I'm going to do, let me just send this real quick. I think I just did that, but let's see if I actually attach the documents. While I'm waiting for the email to go through, for the members of the media who've been asking, the clerk of court has already processed the verdict form, and it is now published on the clerk of court's website at docket identification number, or DIN, D-I-N, 3,629. That's the docket entry, the 3,629. It's on the clerk of court's webpage now. You can grab it there.
Your Honor, I've received your email.
Did I have attachments on it, or did I forget to put
Yeah,
it?
nope, the attachments are both there.
Okay, great. So I'll let the appellate lawyers check that, because obviously we don't need them right this second. So you'll have a couple minutes to look at that. Let's talk about the proceedings. How much time does each side wish for opening statements?
Yeah, I don't think I need more than 15, 20 minutes, Judge, for that.
15, 20 minutes, fine, all right.
So each side will get 20 minutes for opening statement. And is there anything other than we're now in the round two that you want me to tell the jury before we start?
I'm sorry, Judge.
Is there anything else you want me to tell the jury other than we're in the second round of this trial?
We have some exhibits we'd like to admit.
Okay. Let's deal with them.
Could I first, Judge, ask what Your Honor perceives as the scope of what we're doing, how much time each side's got for substance of it?
My understanding was each side was talking about 90 minutes or so.
We're trying to do it within 60 to 90 minutes, closer to 60 if at all possible. We want to get out of here too.
60's fine. I mean, if we're not going to do it.
We're waiting for Mr. Keys. He should be here, though.
Well, he'll be here by the time you're done with your openings.
Yeah, he should be.
And so they say they want 60 to 90 minutes. How much does the defense wish?
That's fine, Judge.
Okay.
Then closing?
How long do you want for closing, Greg?
Is 30 minutes aside enough
30
for each
minutes.
side?
Yeah.
That's fine, Judge.
So I approach it.
So what we'll do, 20 minutes for opening, up to 90 minutes for case in chief and any rebuttal, and 30 minutes closing. How many exhibits are we talking about?
We're talking about 8 to 12.
And let's go through them and
My approach.
sure. Has the defense been handed a
I'm going
list?
to right now.
Your Honor, on verdict form question 9, I think that it rolled over the dates between October 18 and October 20, 2016. I think that needs to be January 6, 2017, sorry.
Did I not? Oh, you're right. Good catch.
I think it was just, it rolled, I'm sure when I block and move things, it just got caught.
I've made that change. Okay, so the first few are these financials?
Yes, Your Honor, and we could proceed with what's labeled there as 2279H and J, which are the most recent tax returns for Johns Hopkins Health Hospital. The two previous ones at Charlie and Delta are there, so we don't face an argument that we're not using the financials from the relevant time period. There was a deposition yesterday of our punitive damages expert where it seemed to be stipulated that we'd be referencing the most recent tax returns. So long as that's the case, we don't need 2279 Charlie or Delta.
Yeah, can I have a copy, please, of what you have as 2279J?
We can put it up.
You know, or just send it to places we print it, please.
Oh, it was provided by Mr. Hunter about in mid-September.
Oh, the one we talked about with Mr. Keys yesterday?
No, you were talking about the fiscal year 21, but
Right.
we went back and looked and saw that fiscal year 22 was provided mid-trial.
Got it, okay. Yeah, just want to make sure we're working off the same document.
So what is the position of the defense on 2279H and J?
Yeah, I have no objection if those are the documents that are going to go off.
Okay, the court receives 2279H and J. Do you have those documents in your possession?
It is, if you don't mind sending them out.
Yeah. We'll need to print these as. Okay.
Yeah, we're gonna need them. Okay, so I've received 2279H and J. What's,
All right, Your Honor. From there, we'd like to proceed with 2828 and 2829 on the same proviso that if we're not going to be required, or there's not going to be a appellate issue about not having the 16 and 17, then we don't need 2826 or 27.
Sorry, Mr. Whitney, I apologize.
That's okay. 2828 is what's been called the audited financial statements for 2021. 2829 is what we've been told were the audited financial statements for 2022.
Yeah, my only objection, Your Honor, is when we took Mr. Heath's deposition yesterday, I asked him what documents are we going to rely on. And he said, I'm only going to rely on the ACH Form 990 from 2021. He said, if I get an updated, the tax return, because their fiscal year is, I think, June to June, if I get the most recent one, I'll update my opinion on that, which is why I don't object to 2279J. But I do object to him putting in audited financials. That was the purpose of the deposition. He told me what he's going to rely on. And now I'm seeing they're going to rely on new documents I haven't had a chance to propose them on. I mean, the ACH Form 990 contains somewhat similar information, but based on the representation you made to me yesterday, for surprise, I would like them to be limited to the tax form that I'm prepared to cross them on.
Is the evidence still in the jury room?
Yes, Your Honor.
any problem with the clerk going to get the actual evidence from the jury room? Okay.
One of the issues here, Your Honor, is that we had a deposition of the CFO of Johns Hopkins Ultra Hospital scheduled for 1 p.m. We had asked for 9 a.m., so it didn't happen.
Well, that's unfair, Mr. Whitney. You asked for either 9 a.m. or 1 p.m., and I gave you 1 p.m. So
Right,
please don't
we gave the
misrepresent.
option, so here we are without a deposition of the CFO. We would move to admit 28.
These are audited financial statements. I mean, are they audited financial
Yeah,
statements?
I'm sure they are. I'm not questioning the authenticity. It's surprise testimony. That's why I take a deposition.
I will receive into evidence the audited financial statements 28, 28, and 28, 29. Now, on the specific issue, Mr. Shapiro, Mr. Whitney didn't put in the 2016 and 2017 financials because of this discussion that y'all were going to rely on the most recent. I just want to make sure that you agree with that.
Yes, Your Honor.
Okay. What's next, Mr. Whitney?
Your Honor, we'd like the court to consider admission of 2451, which is Catherine Beatty's arrest record.
That's still not allowed to come in. So no. What's next?
We would like to play for the jury sworn testimony by Catherine Beatty regarding her cooperation with Sally Smith in other cases.
Let me hear what this is.
And this is 2758 Delta.
It's from the dependency action.
Yeah, let me just hear it, but let me understand the context and then we'll go from there.
It should be your auto clip there, 2758 Delta. Do you have it?
Looks like it's 46 seconds.
It's 30. Page and line is 36, 26 to 37, 14. All right. We're going to move past that one. Let's proceed to, do you have 2830, the video?
On this verdict form, you're instructing on both clear and convincing and greater weight.
Yeah, that's in there. I added that.
You can do both options?
On the verdict form?
Yes.
Yes, that's what we talked about, that the,
Oh, I did not understand. I thought, for heaven's sakes, you were going to still use clear and convincing evidence, which has got to be the finding on that. It can't be it's not a damage element. It's a substantive element to allow for damage.
which is why the question says, something along the lines of, based on clear and convincing evidence, do you find, or something like.
Yes, but then it's followed by one that says greater weight of the evidence. You're giving a para each time.
Correct, because I'm not sure if, I think you're right.
This is like the causation thing. You don't know what the law is, so you're going to give the jury both options right now? Is that what you're going to do? I'm sorry, I object to that. I have to.
Okay, well, Mr. Altenburn, because the law isn't as clear as we need it to be, I am giving both variants. I'm going first with the clear and convincing evidence, and if they find by clear and convincing evidence the specific intent, they will not answer the greater weight. If they answer no to the clear and convincing, then I'm going to ask to the greater weight of the evidence. That way, it gives us the maximum flexibility to address it, and then when and if this goes up to the appellate court, it gives the appellate court the maximum flexibility. I would hate to say it's clear and convincing, and then the second tells me, no, Judge Carroll, it's greater weight, and I got to do this whole thing over when I can just ask one more question.
This whole thing is to make unlimited punitive damages against my client. So I object to all of this, but the record's clear that I have.
I know you vociferously object. Okay, Mr. Whitney, are you ready on your clips?
We are ready with the.
Your Honor, could you flip the?
Oh, I need to flip the control. Okay, I flipped the control. It's just one button. I can do it. What are we playing right now?
This is what's labeled here as 2830. It's a video statement by the current president of Johns Hopkins All Children's Hospital, Alicia Schulhoff.
And how long is this clip?
It is approximately 45 seconds to a minute. 1 minute, 2 seconds.
Okay, let's play it.
Your Honor, let me flip the audio because I had it on the Zoom. Just a moment. My apologies.
As you may know, we are defending ourselves in a trial regarding care we provided to a patient in 2016. We anticipate that the jury will begin deliberating in the coming days. We don't really know how long they will deliberate, but you may hear the verdict before we're able to communicate with you directly. Please know that given the nature of this case, any decision will be complex and will take time for us to fully analyze. As a nurse, I've been doing this for a very long time, and I've seen a lot in my career. And I want you to know that I have never been more confident of anything. More confident that the care we provided to this patient was exceptional, compassionate, lawful, and life-saving.
This case has attracted substantial attention in the media, and much of it has been wrong. What has been made clear in court is that our team of providers did something both heroic and yet for us commonplace.
Judge, this is a comment on the pending litigation. This is, first of all, we've never seen this before. It's never been provided before. This is complete ambush.
Your client apparently did it. I mean,
I understand that, Judge, but sitting here, this is a comment on the defense of the case that is essentially trying to punish the defense for trying the case and defending the case. It's trying to make the defense look bad for defending the case and taking a position with respect to what they've done. They're commenting on what's gone on in court, but it's taken completely out of context, and it should not be admitted at this point.
Any response, Mr. Whitman?
Yes, Your Honor. It's a party admission by the current president of Johns Hopkins All Children's Hospital as to exactly what Mr. Anderson argued in his closing statement, which is they still don't get it. They still maintain their actions were heroic and life-saving, and the jury needs to see this at the punitive damages stage.
Okay, the court is going to exclude 2830. It is not something that occurred contemporaneously, and this is not something that the jury should see. What's next?
Next, Your Honor, is what is there is 2832. We have several clips from town hall meetings conducted contemporaneous with the immediate jeopardy finding as discussed in this
Let's
case.
put that up. How long is this one?
I'll have to rely on Mr. Reyes.
1
for-
minute 14, I think.
Yeah.
No?
First clip is 37 seconds.
37 seconds for the first one.
So let's talk about the survey results. So we did have the 12 surveyors, as you all know, on site. You all, for those who were here, had the opportunity to experience that. There's a couple things I want you to understand. Is when they were here, and you may have heard me say this before, they were surveying us on a federal level, which is around the conditions of participation for CMS, and they were also surveying us at a state level. So this was both a survey for federal regs and also state regs. So let's first of all talk about what immediate jeopardy means, because that's the word that I think has gotten everybody's attention. And just so you all know, this is not my first time to be in an organization where there has been an immediate.
Judge,
So that's 2832.
Yeah, we'll call that 2832.
Is there another clip that's following?
There's several.
Let's do them all, and then we can have a discussion. What's the next number on?
We will call this 2832 Bravo.
I'm sorry, before we keep going, can you identify where on the exhibit list these were?
Are these things that were produced last week?
This wasn't. He came into a deposition with this. This was, as far as I know, this has never been produced to us, never been on the exhibit list. It was played during the deposition of one of our witnesses. We still don't know the source of it.
It's exactly like the homecoming photos of Maya Kowalski that were sent to them by an anonymous source, allegedly. This was provided to us by an anonymous source last week, just before the deposition.
Okay, let's play the next one. 2832B as in Bravo.
The jeopardy that you can receive is something that's called around culpability. And that really is around the issue that leadership knew that there were quality and safety issues and did not elevate it in appropriate ways to the board. And so because of that, there were enough what's called conditions of participations noted that they felt it was important to give us an immediate jeopardy. So I wanted you all to understand that the immediate jeopardy really is about system process issues of the way that quality and safety issues are driven to the board so that the board can govern and act like a board on behalf of All Children's Hospital.
I'll also point out, sorry.
Go ahead.
I'll just point out that Ms. Green testified that she recognized media site, and the source of this is Johns Hopkins, All Children's Hospital, or the health system's internal media system.
What's the next clip, please?
Next would be Charlie, and Charlie would be 46 seconds.
This is a audio. It's an audio clip.
It shouldn't be. No, I'm still on 2832. Just go to the third clip. You have it as 5003. It's 46 seconds.
And when did you first interact with Dr.
Okay. Let's go to 5006 is the next town hall. 5006.
Okay, so what number are we
We're
playing
still,
right?
I'm sorry, Your Honor. We're still going to call this 2832 Charlie. I'm just referencing Mr. Reyes, our internal number.
Okay.
All right. Should be 10 seconds.
Was about information flow, data collection, how you really look at quality and safety, and how that gets fed back up to the board. So that is what immediate jeopardy means. Those.
And one more, Your Honor, 5007, Dan, which we will call, for purposes of the clerk, 2832 Delta.
Is a cultural issue. I think that's what the one thing that has struck me the most is that while on site, the stories that I've heard and the fear of retaliation and retribution if you speak up and speak out. And people have real stories that they've shared with me. And I have that.
Okay, Mr. Hunter.
Three things, Judge. First of all, it was referenced during Ms. Green's deposition, and I'll reference it here. That voice that you're hearing is sped up. It's not his true speaking voice, and it's not particularly complimentary to him. Number two, if they're going to play this, if you're going to let this in, I want to see the whole thing, and we have never been provided that. Number three, we have not previously been provided this, and we'd like to at least have the opportunity to look at the whole thing, because clips are being cut out of this thing out of context, and we don't know what the whole thing is. Okay? There are segments in this thing that were played the other night and that we have discussed internally that in which Mr. Sowers confronted some people and actually apologized for some of the conditions leading up to the immediate jeopardy. But finally, the immediate jeopardy is, with all due respect to Your Honor and prior rulings, that is irrelevant to this case. Your Honor's laughing, but
I'm saying because I just listened to the clips and there was nothing about the Heart Institute, which is what you were telling me in open court all of this was about.
well, Your Honor, and
I'm just saying, Mr. Hunter, it seems what you're saying and what I'm hearing do not match.
And what I was also saying, Your Honor, was that you're only hearing seconds-long clips. You're not hearing the whole thing. You're not hearing the entire matter. And it doesn't sound like you're prepared to listen to the whole matter. But
Time out, because that's a very serious statement you just made. Do you really think I am not making balls and strike calls? I've just eliminated a couple of items from their exhibits, and I'm listening to your statement. So I just want to make sure, are you saying that I am closed-minded in this case?
Judge, I'm suggesting that on this particular issue, you have indicated a predilection regarding the Heart Institute issue that I don't think that I'm able to get past. And that's my problem with it. And on these particular clips, what you're also seeing once again, and I hate to sound like a broken record, but you've just listened. This is a town hall meeting that went on for some period of time. I don't know how long it was. They've got the whole clip of it, okay? A whole clip of it I haven't seen. And frankly, don't to this moment know the entire source of. But you're reacting and visibly reacting to clips from that thing that are seconds long. You're not hearing the whole story. And that's my problem with it, Judge.
Mr. Whitney, do you have the full clip?
No, Your Honor, we have portions of the town hall meetings. They were sent to us in discrete files. There are approximately 9 or 10 of them. As I said to notice, Ms. Green testified she recognized the media system these were being played from on Friday evening. And we had a busy weekend through no fault of our own. But at that point, Mr. Hunter and his colleagues could have gone to Ms. Green and Kevin Sowers and figured out where this resided in the Johns Hopkins system. It resided with them, not with us. So they had, what day is today? Thursday?
Thursday.
They had nearly a week to watch their own video. And the second thing I'll point out is that it's no different than Jack Kowalski having to sit here and listen to clips of Stephanie Graham's interview because we can't admit his that we like. We have to accept them as party admissions, and they should be forced to do the same of clips.
Have you turned over any other clips that you have not played here that they can see? Did you get anything else?
Yes, Your Honor, there's more to this, but they've never asked us to produce these clips.
Well, if the defense wants to see those additional clips, that's fine, and they should be able to see them.
Well, I would add to this, Your Honor. We tried to find this thing, and we couldn't. And I understand that Ms. Lawrence is related to a past or former employee of ours. I don't know whether this is the source of that
That's
or
a
not.
false allegation. I mean, that's true that she is related to a former employee, but that was not the source of these, and that's a false allegation.
I just said I don't know.
Okay, well, I'm just clearing it up. It wasn't from that person.
But the point is, there is a rule of completeness and context here that irrespective of whether I get the complete set of clips, which I appreciate, irrespective of whether I get those or not, these things are clips that got taken out of context and are being played as party admissions, even though the whole story and the whole statement isn't being played. And that's highly prejudicial, and it is also ambush, and it just shouldn't be taking place, Judge.
The court's going to receive into evidence 2832, 2832, B as in Bravo, 2832, C as in Charlie, and 2832, D as in Delta. What's next, Mr. Whitney?
We have
I'm sorry, Judge. Am I to be provided the balance of these clips?
Yeah, didn't I just
We will
ask him to
send
do
him
that?
over immediately.
I didn't.
I apologize if I thought I had said that they need to see it.
And we're going to send him immediately, Your Honor.
Thank you.
The next is, Mr. Reyes, you have this as 5003 on your system. Your Honor, on the exhibit list here, it's 2758 Delta, and it is an audio clip of Ms. Beatty's sworn testimony.
And when did you first interact with Dr. Sally Smith?
Professionally,
Yes.
I've known Dr. Smith, or known Dr. Smith for probably 15 years.
Okay, so you've known her for 15 years. Do you have a personal relationship with her?
No, just professionally, I see her here at the hospital, and I've worked other abuse cases with her.
Okay. And approximately how many other abuse cases have you worked with her?
With her, probably here through the hospital, at least, I'm going to say 75 to 100, and in the last 15 years, probably close to 300 or 400.
She's an agent of the hospital, employee of the hospital. It's a sworn testimony. It's a statement against interest. It goes to, and they just checked yes on apparent agency. It goes to the pattern and practice of this institution. And for the record, we have filed a memorandum. We were waiting to see what the jury did. We filed it at 2/27. It's a memorandum regarding the second stage of punitive damages and talks about the relevant, the determinations of relevance in the context of a phase stage 2 like we're at here.
Mr. Hunter, your statement on
Judge,
Exhibit 2758D as in Delta.
Judge, A, it's from the dependency action. B, it's irrelevant. C, 227, a memo, I mean, I haven't seen it. And I doubt if the honor has.
I haven't seen it, but I understand the standard.
The jury checked the yes box with respect to Sally Smith. That issue's been settled. This issue is not relevant going forward on this, and this shouldn't be admitted.
Well, I agree they checked yes on apparent agency with respect to medical malpractice. And so I don't see why the statements about, and clearly Sally Smith was wearing her hat as a medical director of the child protection team, presumably in these other cases. And so I don't see how that language is relevant for a punitive damage claim. So I'm going to exclude 2758D as in Delta. Anything else?
One more, Your Honor. It's 2831 on the list here, and this would be 5004 on your system, Dan.
Around, but they're different. It's the way they cut. Here you see the eyes, here you don't. So if they do it this way versus this way, I mean, I'm not trying to argue with you. I'm just telling you what I see, and I understand what you're saying. I understand the position.
I mean, the situation we're in right now is because, they think we abuse our child and we take them away from us.
I understand that.
It's not, and we have to prove our innocence to try to get him back. I mean, so, here, it's not anything that, we can take lightly and easy.
No, and I understand. And I think all you can do is get different opinions. I mean, our radiologists have read it. You've had other people read it. Dr. Smith is our child protection person, Sally Smith. She's done that for years and years and years. She's the person who usually does all that. So
yeah, she felt just in for 5 minutes, and
but,
she was the one that.
But the problem is, to me, because there's so much controversy and nobody will probably agree on this because it's not cut and dried, and he didn't have retinal hemorrhages.
He didn't have anything else.
He didn't have, well, retinal hemorrhages are important because that's an important sign of shaking injury. So,
All right, wait a second. Is this talking about someone else?
Yeah.
Yes, sir.
No. Not coming in. 2831, it's not coming in. Anything else?
Nothing else, Your Honor.
And we can do the defense exhibits after they rest. Is that appropriate for the defense? Okay. Are we ready to bring in the jury?
Judge, before the witness list, what's being called?
Mr. Anderson, Mr. Anderson. Mr. Anderson, come on, let's focus here. There was a question by Mr. Hunter. Each side's got their 90 minutes for witnesses. So what was your question, Mr. Hunter?
I've got, there's a list here of several witnesses in addition to Mr. Heese and Ms. Salisbury and Dr. Corcoran, and I'm trying to find out if somebody else is going to be published or played, or if there's going to be other witnesses beyond those people. This is the first time I've seen this. I mean, this is like, I mean, they were told yesterday who we intended to call in the punitive damage phase, indicated we were not told anything other than Mr. Heese. And this other stuff being brought up is classic ambush.
Mr. Whitney or Mr. Anderson, I don't know who's handling that.
Yes, sir. We have Mr. Heese. We would like to call Saisha Mercado.
We object to Ms. Mercado. She's another person that is alleging misconduct during a child abuse investigation.
I'm not getting into other people's Chapter 37 proceedings. We're not doing that.
We would like to call Ms. Salisbury.
We would inquire what she's being called for.
Well, one of the things she's been called for is to discuss that she has had the opportunity to take the deposition of Dr. Sally Smith. And in fact, that was at Johns Hopkins All Children's Hospital, where Sally Smith was wearing a Johns Hopkins All Children's Hospital lab coat during the deposition.
They've already
Why do we need that? That's already been found by the jury.
She also, and we have an internal work product memorandum. She's also would testify as to the pattern practice of Johns Hopkins All Children's Hospital calling in Sally Smith ahead of any investigation, and the long-term damage that's done to families by this practice of Johns Hopkins All Children's Hospital and Sally Smith.
We object. The chilling effect already on mandatory reporting is shocking. We object to any more coming forward on behalf of abused and neglected children.
Under the law, the hospital has immunity for calling the hotline. We're not going to parade a whole bunch of people in and talking about other people's calling of the hotline and what happened because of those calls to the hotline. That's just not going to happen. So you can keep saying these people are going to be called, but I'm not allowing it. So
May I make one further point?
you may.
Except that the testimony won't be it was the result of a hotline call. It was the result of the same practice here, which is involving Sally Smith as a hospital pediatrician ahead of any hotline call, ahead of any Chapter 39 involvement.
I'd like to just make a quick record on this.
I'm saying no.
I understand, but
Okay, go ahead.
This is the problem that's infected this entire trial. Respectfully, I know Your Honor's trying to keep this out, but they've made their entire case about the involvement of Sally Smith to try to destroy the lines between what was immunity and what's not. And their whole argument about the apparent agency of Sally Smith was not for the medical care she performed at the hospital, but her role as a child abuse captain. We'd asked for this to be excluded, but we'd also noted that they're continuing to try to infect this jury with Chapter 39 issues that should have been and have been excluded. We object to these witnesses.
Well, I think I've already declined to allow that witness to be called. What's next?
Our case has been greatly simplified. I think our
There
only
we go.
witness will be Steve Heese.
Okay, so there's. Okay.
Can we have, I know you want to bring him in immediately, Judge, can we have just, you can stay on the bench just 2 minutes, because that really cuts down on a lot of our case, and I just wanted to reorganize notes for 2 minutes.
I will tell everybody I will be back in at 3:10. Tell the jury they need to use the restroom, but we're going to start at 3:10, okay? I'll be back at 3:10.
All rise. Scores in recess.
In light of the findings from the first round, we now move into the punitive damages phase. We're going to have opening statements from the plaintiff and then the defense. Plaintiffs?
Time no see. Thank you for the past 9 weeks. We've just got a little bit more to go. So this is where we determine the amount of money necessary to change corporate behavior and make sure this kind of stuff never happens again. And what our case is based around are those series of emails and memos you saw coming down from the highest up, the general counsel, over to risk management, and then directly down to Beatty and the folks kind of on the ground level, I guess, of the interaction with Maya that brought that verdict from you. So what we want to do here now is have you focus, and we can we'll bring them up as necessary. That series of memos when you're back there, you probably already remember them, when there were directions to do these things from the highest level of the company. And that's what we're talking about when you get a question on here about specific intent. It's not just like a general screw-up of the company. It's about whether the company management, for its own reasons, decided on a course of action that they had to know. And in fact, in addressing it, address the fact that it was going to harm this little girl. And this is somebody who is vulnerable by herself. She cannot get out of the way. She cannot escape. So it's about protecting the most vulnerable people in that hospital and in our society. So that's why we have punitive damages in this country. It is to force a change in corporate conduct. It is to overcome the inertia of we've been doing it this way for a long time, and we got hit for a malpractice award. Let's put it over here on this part of the balance sheet, and if we're lucky, maybe the president won't hear about it. You need to make an award to make sure there's absolutely no question. Everyone in that organization, all the way up to the top, hears about it. And we're going to bring here, I think Nick's going to take him, Stephen Heese, who's the president of Chris Craft Boats. They're right over here off 15th Street next to the airport, the nation's oldest boat manufacturer. Been around for 160 years. And Steve's not that old. But he's going to come in and explain to you a little bit about managing risk and why these kind of verdicts are important. Number one. Number two, fantastically, he's also a certified public accountant and was a partner at PricewaterhouseCoopers. So he knows how to run these numbers. So what we did was we had them produce their tax returns and their financial statements, their audited financial statements. So we know how much money they were making, and we had Steve calculate their real net worth based on the furnitures, fixtures, equipment, income, the $555 million in gross income they made one year. He's going to list all those out for you. Please take notes on the specific numbers as they come in. And what we want to do here is assign a certain percentage out of net worth, out of revenue, or both, and that is within your province. But to effectuate what you checked, yes, you believe punitive damages are warranted, it must be enough money to absolutely make sure that the highest levels of a very, very large company hear about this and are forced to make the changes necessary to ensure that this never happens to another family. That's the mission. All right? So you'll get a verdict form, and it'll have several questions. This one, thank goodness, is only 9 pages long, so you won't have to spend reading another novel after writing a novel on each witness. And you'll go through it, and it'll have questions that ask you, based on Mr. Heese's testimony, on the various the incidents that we're talking about, I don't know, it just is so insulting to call these things incidents. The damage, the injury to Maya and her family at different, the same ones you saw before and checked yes to. And there are two types of questions. One is, on clear and convincing evidence, how much per incident, just like you did before. And the second one is, importantly, about specific intent. And that is where you signal whether you understood and agree that from that highest point there, they had made up their mind to initiate a policy that led to what you saw for 9 weeks. And so you can have any evidence you want. It's all back there. You can go back and check those emails. I made a big deal about them in my opening 9 weeks ago. If you need those, check them out to confirm what we're saying is correct. But you'll see there that risk management had directed this stuff, and that's why it's so important to get into that specific intent. Because again, this is all about sending a message. The first part of your case was about compensation. Now that's over. Now what we're doing is correcting behavior. All right? We're correcting behavior. And again, I keep saying these things because you all have been around this planet long enough to know how companies act, how people act. And you know that to get people to change and to get companies to change takes a lot. And so that's why these numbers are going to be big. As big or bigger than what you've already awarded. But they're based on a different scale, and they're based on how much the company is worth. It's a $1 billion company plus, and how much it makes per year. And these are the only ways that our country has come up to find a way to change corporate behavior. So at the end of it, I'll have a chance again to talk to you about it. I'm keeping this short. You've done a fantastic job so far. We only need you a little bit more to do the right thing here on behalf of, now you're talking not only for the Kowalskis, but for everyone. Okay? That's all I got to say right now.
Mr. Shapiro.
Good afternoon. No surprise, obviously, my team is very disappointed by the verdict. But I do have a chance to talk to you one last time about what they're asking you to do. I represent a nonprofit organization that's a children's hospital. You're going to hear testimony that every dollar that is awarded in this phase is a dollar that we don't have to spend on medical care in this community. You're going to learn a couple things. And it's simply this. The Kowalskis, so your verdict, have been... so the punitive damages, so you know, are only for... I think you signed the verdict form, and I know you spent a lot of time with it. They're for the false imprisonment and the batteries, right? They're not for medical care. By my math, you've now awarded $57 million to the Kowalskis for the photographs and the false imprisonment, and total compensation for the Kowalskis is approaching $250 million. I would suggest to you that's fair compensation, more than fair compensation. In terms of what they're asking you to, so these punitive damages are to punish and deter, right? So a couple things to keep in mind. Obviously, I don't have a chance to just sit down with you and find out what drove this specific anger. But if it was Kathy Beatty, she no longer works at the hospital. So that's not something that you have to keep in mind. Do we need to punish or deter for anything she did? If you found that there was something that she did that was improper, I would suggest to you that's not something that you need to send a message on. I also remind you, in terms of if this is corporate misconduct or something you heard from Mr. Corcoran that you thought All Children's was doing improperly, I would remind you Mr. Corcoran did say that after whatever surveys came down that he was concerned about that All Children's did an excellent job of correcting them, and now there is an open culture of communication that can reach the highest levels, so we wouldn't need to see any type of message coming from this jury to correct any future conduct, because all of that's been corrected. But again, we would suggest to you that on the false imprisonment, just keep this in mind, and I don't want to re-argue the evidence because obviously you disagreed with me. But in terms of punishing, deterring, I thought I did what I could to let you know that the reason why All Children's back in that first week where you've awarded a lot of money for what they called a false imprisonment, just that 1 week before the abuse hotline led to the shelter, that all children's did that because they were concerned for Maya. And I do fear that a verdict on punitive damages to punish and deter healthcare providers for speaking out when they see children that they think are susceptible to leaving and being put into a ketamine coma that they believe is dangerous, to being taken and put in intrathecal clonidine pumps that they think could lead to patient death, that sending a message for punitive damage is really going to create a silencing effect at my hospital, where it's going to chill people from ever speaking up again. So, we won't take too much more of your time, but I would just humbly suggest that since we are talking about policy, that there's been $250 million awarded to the Kowalskis, and punishing and deterring and trying to silence healthcare providers when they have a genuine concern is going to be tragic. I look forward to talking again once we're done this process. Thank you.
Plaintiffs, call your first witness.
We'd like to begin, Your Honor, if we could, by publishing several exhibits of videos.
You may. So long as they're in evidence.
They are, Your Honor. We will begin by publishing 2832 Alpha, previously admitted. This is a video of a town hall meeting at Johns Hopkins All Children's Hospital, concurrent with the immediate jeopardy. You can play it.
So let's talk about the survey results. So we did have the 12 surveyors, as you all know, on site. You all, for those who were here, had the opportunity to experience that. There's a couple things I want you to understand. Is when they were here, and you may have heard me say this before, they were surveying us on a federal level, which is around the conditions of participation for CMS, and they were also surveying us at a state level. So this was both a survey for federal regs and also state regs. So let's first of all talk about what immediate jeopardy means, because that's the word that I think has gotten everybody's attention. And just so you all know, this is not my first time to be in an organization where there has been an immediate.
That video excerpt. We'd next like to play 2832 Bravo, previously admitted, further from the town hall meeting.
The jeopardy that you can receive is something that's called around culpability. And that really is around the issue that leadership knew that there were quality and safety issues and did not elevate it in appropriate ways to the board. And so because of that, there were enough what's called conditions of participations noted that they felt it was important to give us an immediate jeopardy. So I wanted you all to understand that the immediate jeopardy really is about system process issues of the way that quality and safety issues are driven to the board so that the board can govern and act like a board on behalf of All Children's Hospital.
Next, 2832 Charlie, another clip from the town hall meeting.
Was about information flow, data collection, how you really look at quality and safety, and how that gets fed back up to the board. So that is what immediate jeopardy means.
And to conclude the video clips from the town hall meeting, 2832 Delta. If you could turn this up a little quieter.
If Your Honor has the ability to increase it from the bench, that's as loud as I can get it.
That's as loud as I can do it. I don't know if we'll get any feedback, but there you go.
It's a cultural issue. Because, I think that's what the one thing that has struck me the most is that while on site, the stories that I've heard and the fear of retaliation and retribution if you speak up and speak out. And people have real stories that they've shared with me. And I have that.
Next, Your Honor, we would call Stephen Heese to the stand.
This way, sir. You stand here, face the clerk, you raise your right hand.
Please solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do. All right, we're gonna come this way. You're gonna have a seat, not stand there.
The police escort.
Next seat.
afternoon.
Good afternoon.
Thank you for being here on short notice. Would you please state your full name for the record?
Stephen Heese.
And would you please introduce yourself to the jury by way of your current position and profession?
Sure. I'm the president of the Chris Craft Boat Company in Sarasota, Florida. It's America's oldest boat builder, been in business for 150 years.
Thank you, Mr. Heese. I'd like to discuss for a few minutes your background, training, and experience. The jury knows the drill by now. But would you please give us the benefit of your formal education in business?
Formal education. I have an undergraduate degree. I grew up in Tampa. Went to Jesuit High School. Went to Tulane University in New Orleans. Got a degree in accounting. Worked for several years at Price Waterhouse. Went to business school at Harvard University in Boston. And that's the limit of my education.
Sure. Did I understand, and it was a Master's of Business Administration, an MBA from Harvard Business School?
Yes, with a concentration in finance.
Understood. And that was very brief. I'm going to explore it a little bit more. You mentioned, if I heard you correctly, that you worked at PricewaterhouseCoopers between undergrad and business school. Is that correct?
That's correct.
What was your role and function at PricewaterhouseCoopers?
Started off in the audit department, and then after I became certified as a certified public accountant, I switched to the management consulting department and installed enterprise resource planning software for the next following 3 years.
And how long were you at PricewaterhouseCoopers again?
Almost 5 years in total.
In those 5 years, did you have an opportunity to work within the healthcare industry?
Had audits of healthcare providers, hospitals.
Anyone that the jury might know?
Tampa General Hospital.
All right. And so you audited and analyzed the finances of Tampa General Hospital during those years?
That's correct.
And so you have familiarity with the finances of large hospital systems, is that correct?
Yes. I also grew up in a medical family. My mom was a midwife. My sister's a nurse. I have aunts and uncles that are nurses and doctors. My daughter is a pediatric ICU nurse at Children's Hospital in New York City.
And we don't need. What took you from Harvard Business School to president of Chris Craft?
Since business school, I've made my living buying broken companies, fixing them, and selling them, particularly in the power sports business.
And so, am I correct in understanding that Chris Craft, when you purchased it, perhaps was somewhat broken?
It was at a bankruptcy auction, completely shut down in 2000. It had gone bankrupt.
And you've been the president of Chris Craft for how long now?
23 years.
And under your management, has Chris Craft been successful?
Yes.
How many employees do you have at Chris Craft?
About 400.
And through your management of Chris Craft, have you had to purchase and manage the healthcare benefits and systems of Chris Craft?
Every year.
If you could, let me ask an open-ended question. Is risk management a concept that you learned at Harvard Business School?
Object to relevance foundation and relevance to this percent.
Overall. You can answer. Risk management, the concept of risk management. Would you please explain what that means, whether you're talking about the healthcare industry or you're talking about the marine products industry?
Sure. In any business, there's risk. Risk is something that every business has to manage. Many risks cannot be eliminated. In the marine industry specifically, boats have propellers, they've got fuel tanks, they've got carbon monoxide, they're used in the water. People are having fun when they're using them, often eating and drinking. These are genuine risks that a manufacturer has to understand and manage and do their utmost to mitigate.
What role does culture play within an entity, whether it's Tampa General Hospital or Chris Craft, in terms of the risk management attitude of the employees and leadership?
Objection again, foundation.
Overall. Could you ask the question again?
Sure. What role does culture play in terms of whether you're looking at an entity like Tampa General Hospital or Chris Craft as it interacts, culture interacts with risk management?
Again, foundation speculation.
Overall,
It plays an important role, but not the only role. But for sure, the attitude of the employees is reflecting on the attitude of management and management's approach to managing the risk. So, if management is seen to be insisting that people are certified, insisting, with the standards that govern their activities, and if there's procedures in place to deal with exceptions, employees know that the employer is seeking to do the right thing at all times, top to bottom, and that culture gets created where those risks can be managed and mitigated.
Having taken over Chris Craft when it was in the midst of bankruptcy, did you have a challenge in creating the proper culture within Chris Craft to take it from bankruptcy to success?
I've been committed to standards and training of employees, and so those are the foundations. Systems, training, ideally outside certifications and training, written procedures that are followed and reviewed. These are the fundamental building blocks of risk management.
Throughout your career, whether it was at the beginning of PricewaterhouseCoopers or in your past 20-something years with Chris Craft, have you seen instances where the culture was such that it allowed retaliation and retribution for employees that spoke up about doing the right thing?
Objection, foundation scope.
Overall,
I have certainly seen that.
And how important is it to stamp out that type of culture that would allow such actions by leadership?
If the company is going to sustain itself, it's really important, critically important.
All right. Now, I'd like to discuss with you your report, which I believe you might have a copy there, and let's just keep it there for now. You'll have it as a reference. If you need to refresh your recollection, let me know. But for now, let's just try to do this from memory and your general understanding. Have you had an opportunity? Well, as part of your presidency of Chris Craft, do you monitor the industry for punitive damages awards?
I need to approach on this one.
approach.
our job keeps getting easier. Let's turn to what has been marked as 2279H as in hotel. If we could publish this, please. And the jury will have this document with them when they're deliberating regarding punitive damages. The jury will also have 2279 Juliet, as in J or Juliet, which is the next year's tax return. But let me start here because, first of all, would you explain to me and the jury what we're looking at here?
The first page is irrelevant.
What document is this?
Oh, it's a tax return for the 12 months ended June 30th, 2021. And it gets filed on the previous year because it's in the middle of the year. The new tax form isn't done, so they use the tax form for the previous tax year.
And informing your opinions, is this the document that you relied upon?
Yes.
And so it says 2020 in the top right corner.
Yes.
But if I understood your testimony, you're telling this jury that Johns Hopkins Children's Hospital files their taxes mid-year, so they would have filed in mid-year 2021, even though this says 2020.
Correct. So if you look in the middle of the page at the top, it says for the calendar year 2020 or the fiscal year beginning July 1, 2020 and ending June 30, 2021. And so that the forms all follow that same time frame.
All right. Now, focusing there on page 1, would you please tell the jury what total revenue was for Johns Hopkins All Children's Hospital in the fiscal year ending June 30th, 2021?
Yes, so you have to go to page 9. I don't know if you all have this in front of you.
We can get to whatever page you need, so you direct us.
So page 9, and the pages are in the upper right-hand corner. Total revenue for that year was $555 million. And that's in the bottom of column A, at the bottom of page 9.
Can you help me, please? It says page 7. There you go. I'm sorry. These documents are not familiar to us. They're familiar to you. So if you could re-express what you just said. So now the
Sure, the
jury
beginning
has
of this is just checklists and required disclosures by the IRS.
Mhm.
But the financial statements start on page 9 with the page number in the upper right-hand corner where it says page 9.
And you should have that in front of you on your screen. And
Yes.
the jury has the same. So if you would direct us to the figure that you were just discussing.
Column A, which the columns are labeled at the top, it says total revenue. And you go to the bottom of column A, and it's highlighted in yellow on what I'm looking at on the screen, $555 million.
So I imagine the jury knows the answer to this question, but for the record, what is total revenue as expressed here? What is that?
Billings, invoices, charges that the hospital sent out to its patients and other people that it provided services to.
All right. So you're aware that we're here to discuss a punitive damage award if the jury deems that appropriate here. Direct me through the document as to what figures and categories you would look to in determining what resources are available to Johns Hopkins All Children's Hospital to pay any punitive damages award that the jury deems appropriate.
So it starts on page 9, but if you go to page 11, it's the balance sheet of the entity. It's a nonprofit, which means that it seeks not to make a profit. Any extra cash that's left at the end of the year gets invested in the company the following year.
As of, you can stop scrolling, please. And if you could scroll up so we can see the page number at the top so the jury's oriented, they'll have that back there with them. So we're at page 11.
Yep. So
cash, non-interest bearing.
So that's $62 million that they have in there. Cash, non-interest bearing, that's typically in a checking account. Checking accounts don't pay interest, so that's at the end. It's column B actually. $46 million at the end of the year. The $62 million number is the start of the year. Column B is the end of the year, the $46 million.
So the jury can understand that at the end of the fiscal year 2021, June 30th, Johns Hopkins All Children's Hospital effectively had $46 million in its checking account?
That's on line 1, yes. But really, to get a clear picture, you need to go down to line 11 and add the balance of line 11, which is $518 million, which is publicly traded securities. So
Okay.
those are
Yeah, please.
those are stocks and bonds that you could decide today that you wanted cash, tell your broker to sell them, and you'd have cash tomorrow.
So that $518 million figure here, it would not be difficult for Johns Hopkins All Children's Hospital to liquidate those publicly traded securities.
And write a check 2 days from now.
They're traded on public markets.
It says publicly traded securities. People don't usually lie on their tax returns, so I would say yes, that is publicly traded securities that could be sold.
And if we do, just focusing on line 1 and line 11, if you're good at mental math, imagine you are, what are we talking about here for resources available to pay a punitive damages award so far?
$570 million roughly.
What other lines or figures would you look to on this form to determine if there's any other assets?
Right below there, you have almost $6 million in other securities, and then line 13, you got another $24 million in program-related investments. I don't know what those are, but they're certainly investments, and there's money sitting there.
By the way, were you available to attend a deposition of the CFO of Johns Hopkins All Children's Hospital this afternoon at 1 o'clock?
I was available.
And given what's happened here today, you didn't have the chance to hear that testimony, did you?
No.
So you haven't had an opportunity to explore, as we sit here at 3:45, what this program-related investments are?
No.
All right. So, considering those, am I correct that if you were at $570 million more or less before we add another $30 million, we're now at roughly $600 million?
Correct.
Are there any other figures that you would look to on this form to determine what Johns Hopkins All Children's Hospital would have available to pay a punitive damages award?
If you go further down the balance sheet, there's fixed assets, property, plant, and equipment, and real estate. So if you
And you said further down, are we looking at a different page now?
let's have a look.
Sure.
I'm sorry, line 10A.
On the same page?
10A and 10B.
All right.
So there's $394 million roughly in property, plant, and equipment, and that number is purchase price less depreciation. So it's what was paid for it originally, less depreciation each year that goes by. Land doesn't get depreciated, so it was bought a long time ago. So I'm guessing it's substantially undervalued compared to these numbers.
And if I'm correct, the depreciation there is a tax concept, right?
Correct.
But if the purchase price here was, it looks to be $650 million for the real estate.
Land buildings and equipment.
$650 million.
Correct.
And so the figure there in the right column, $394 million, is after depreciation, but that doesn't reflect the true depreciation in value. That reflects how it's held on the books after depreciation is accounted for.
Correct.
So you made a statement that the $650 million, the $394 significantly underestimates the real estate assets available to Johns Hopkins All Children's Hospital, right?
Typically, yes.
And is it your opinion that if the purchase price was $652 million, that Johns Hopkins All Children's Hospital would have real estate assets in excess of that amount given inflation, appreciation, et cetera?
Yes.
Calls for speculation.
And again,
I think everyone knows what's happened to Florida real estate over the last 10, 20, 30 years.
Sure. You say you're from Tampa.
Yes.
How long has All Children's Hospital, if you know, been in that location, in those buildings on that campus?
Since I was a child.
Does that support your opinion that these numbers here are significantly undervaluing what the worth of those real estate assets is?
Yes.
Okay, but we can go with the numbers that we have here. So before, we were at $600 million in cash and cash equivalents, am I correct?
Yes.
And here, although it's significantly underestimated, we have another $400 million in real estate assets as it's held in the books.
Land, building, equipment, yes.
And so we're at approximately $1 billion now
Yes.
that Johns Hopkins All Children's Hospital will have available to pay any punitive damages award.
Yes.
May I have a moment?
You may.
Thank you. Great.
I'm also guessing that the hospital has insurance, typically.
Well, I move for mistrial. That's unbelievable.
He doesn't know.
Members of the jury, on that last comment you heard about insurance, the first thing you need to do is totally disregard it. The second thing, I'm going to tell you that under Florida law, insurance does not address or cover punitive damages. So there is no insurance for punitive damages. So you are to totally ignore the comment made about insurance coverage. Mr. Whitney, you may continue.
Are there any other figures on the balance sheet here that we haven't focused on that would inform your opinion as to the assets available to Johns Hopkins All Children's Hospital to pay a punitive damages award?
No.
Having reviewed the balance sheet here with the jury, page 11 of 2279 Hotel, have all of your opinions been based upon your background, training, and experience and offered to a reasonable degree of accounting and management probability?
Yes.
And ultimately, what is your opinion as to the resources or assets available to pay any punitive damages award in terms of the numbers we've discussed on this sheet?
At least $1.2 billion.
When you say $1.2 billion.
Correct.
No further questions this time.
Mr. Shapiro.
Sure, thank you. Mr. Heese, you've known Mr. Anderson for what, 20 years?
Yes.
You guys were hugging and high-fiving in the hallway, weren't you?
What do you mean?
I saw you hugging and high-fiving Mr. Anderson in the hallway. Were
I
you
high-fived him.
All right. Let's talk a little bit about your opinions. This is a non-profit charitable organization, true?
It filed a tax return on a non-profit tax return, so I'm assuming it's a non-profit entity.
Yeah, this is a children's hospital. That's my point. You know this is a non-profit 501c3, true?
Yes.
All the money, and I think you said this in fairness to you, all the money that's left over at the end of the year gets reinvested back into the community, true?
I don't know about the community, the entity.
Right, and do you know what the charitable mission of All Children's Hospital is?
I am not aware of that.
It's right there on the tax return. Before you testified, you didn't look?
You can draw my attention
Sure,
to that.
2279H002. We can put it up on the screen. See summary part 1?
Yep.
What does it say?
I was looking at part 3. Part 1, which page are you on?
Please briefly describe the organization's mission and most significant activities. Am I reading this right? Provide leadership in child health through treatment, education, advocacy, and research. Is that right?
Strive to provide the highest quality of care to improve the health of the entire community through innovation, collaboration, service excellence.
Well, let's talk about innovation. Are you aware that All Children's has a training program to train the next generation of doctors and residents?
No.
You've lived in the community for 20 years. You had no idea there was a residency training program?
Did not know that.
Did you know that All Children's receives grants to do research?
Yes.
Okay. Let me ask you a little bit about, you talked about revenue of $555,256,053. There's expenses, aren't there?
Yes.
What were they?
If you look at the following page, the total is there. $519 million.
And that was with CARES Act money, true, right?
I don't know the answer to that.
Well, you can look at the prior year. They actually spent more than they took in, true?
The prior year's not on the page.
All right. Let me ask you this. Whatever All Children's doesn't spend as a 501c3, you know they have to they reinvest it back in the company, right?
Not necessarily. They've got an awful lot of cash on their balance sheet.
Well, let's talk about that. Are you aware of what their strategic plan is?
I'm not privy to that.
Okay. Do you know what All Children's plans on doing with the cash in the balance sheet in terms of helping this community facilitate patient care? Do you know?
Given that the cash balance is fairly stable from year to year, I would say they invest it.
When you talk about property, you mean the property where the hospital sits, right?
The line is called property, plant, and equipment, so that would include the land that the hospital sits on, yes.
So if they sold the land where the hospital sits on, there's no more hospital.
No, you could do a sale and lease back.
Okay, and if they sold property that they may hold in Sarasota, Florida, where they were going to build a clinic to, for example, take care of children dying from cancer to pay this award, that would hurt the community, wouldn't it?
Objection.
Overruled.
You ask the question again.
Yeah, if when you talk about selling property, this isn't beachfront property. If they're selling property in Sarasota County where they're trying to build an outreach center to help treat children who have cancer so they don't have to make the drive to All Children's, that would be the type of property they would have to sell, right, Mr. Heese?
What I'm suggesting is they don't have to sell it to a third party who's going to put up a 7-Eleven. They could sell it and do a lease back, continue with their strategic plan, and pay rent if they needed to. But I'm also suggesting that I don't think they need to because they're sitting on an awful lot of cash.
That cash is needed because if you don't have an adequate balance sheet, you can't borrow money, can you?
It depends on what assets you have. There's all different ways to borrow money.
There are credit rating agencies that look at the hospital's financial stability, and if they're not properly financed, they can't get money. True?
If the balance sheet is in poor condition of a company, it will have a hard time borrowing money.
Right, because if there's $200, $300, $400 million going out the door, that's going to have an adverse effect on the balance sheet of a company and their ability to continue to do business. True?
No, it depends on the cash balance that's there at the beginning and what gets paid out.
Well, let me ask you, you said operations include equipment. That would include ventilators keeping neonatal children alive. True? That's equipment.
It would include all the equipment the hospital owns.
That would include the MRI machine that can detect early brain cancer and potentially save lives. True?
Equipment typically goes down in value. Land and buildings go up in value.
Right, and that's why they have to do constant upgrades on equipment with the cash they have, so they don't have outdated technology. True?
Correct.
Do you sit on a board and decide when, well, let me ask you this. As president of a company, you have to decide where to allocate your dollars, right? Money's fungible. Money, if you lose money in one area, you don't have it to spend somewhere else. Do you?
Correct.
And have you ever had to sit on the board of a children's hospital to decide whether to upgrade the MRI machines that are detecting cancer versus the ventilators that are keeping neonatal children alive? Have you ever had to do that?
No.
Have you ever had to make the decision as to which outreach clinics you were going to fund, whether you're going to continue to expand in Sarasota versus Pasco County versus Polk County? Have you ever had to do that?
No.
When you took over your company, you said it was in bankruptcy?
Yes.
Did you make changes to it?
Yes.
And as a result of the changes, did the company improve?
Yes.
One moment here. That's all I have for you.
Any redirect?
Briefly, Your Honor. Mr. Heast, were you deposed yesterday afternoon?
Yes.
How long did that deposition last?
15 minutes.
Were you asked any of the questions you were just asked here challenging you in that way?
No.
Am I correct that the purpose of the deposition yesterday was just to find out what document you'd be relying upon?
That was the main, seemed to be the main question that got asked.
And you told them yesterday you'd be relying upon the 2021 tax form we looked at today, right?
Correct.
Hold on a second. I have on Zoom and now Miss Angela Green and others.
Well,
So
put her in a waiting room, Judge.
I'm going to do that. Sorry about that.
That's all right. Thank you. I don't know if I got the answer out there that I wanted, but you testified yesterday, consistent with today's testimony, that your opinions would be based on that tax return form.
Correct.
Since the residency training program was brought up, are you aware of the role that Dr. Sally Smith has played in this case?
Yes.
Objection, speculation, relevance, foundation.
Sustained.
You mentioned a concept there that was not explored that I'd like to explore a little bit, sale leaseback. Would you please explain, let's just be specific here, if we're talking about real estate assets. What is a sale leaseback?
It's a huge industry in the United States. I get a phone call practically every week from representatives of investor groups that like to buy real estate and then lease it back to the owner. It's a way to raise liquidity if it's needed.
So it's
investors
a way,
love it.
Is it a way to unlock value out
Correct.
of your real estate assets?
Correct. Get liquidity out of real estate.
And Chris Kraft, right? You receive these offers?
Yes.
And so if you were to enter into a sale leaseback arrangement, can you explain the mechanics of that a little bit more in detail for the jury?
Sure. The land gets valued by an independent appraiser. There's an advance rate against that value. So say the land value is $1 million. They'll loan you 80% of it. They'll pay you 80% of it and lease it back to you, giving a return to the person that buys the land and buildings.
And then you effectively pay rent.
Correct.
And so, using those figures, we discussed a moment ago, did we not, an underestimate in terms of plants, property, equipment of $400 million?
Yes.
And you believe that to be significantly undervalued?
Yes.
But if you're able to unlock 80% of the value of those real estate assets, considering that it's $400 million, what are we talking about? What number?
Easily 75% of that number.
And so that'd be $300 million?
Yeah.
And if the hospital, Johns Hopkins All Children's Hospitals, enter into an arrangement like this, they'd be able to continue operations in their hospital as it exists.
Correct.
You wouldn't be shutting down a children's hospital by doing it.
Objection, litigation, speculation.
Overruled.
You wouldn't be shutting down a children's hospital by entering into a sale leaseback arrangement, would you? It would depend on the amount of the punitive damages, but if the sale leaseback paid the punitive damages, you could have all your cash on your balance sheet and keep it there.
And so if you consider the cash on the balance sheet of $600 million and sale leaseback income $300 million, what figure are we talking about that would be available to pay punitive damages award? Well, in total, you'd add the cash and the value of the real estate. And 600 plus 300 million. 900 million. And again, are all your opinions to it reasonable management and accounting probability? Yes. Thank you.
Absolutely.
So just so we're super clear on this leaseback agreement that you think the hospital should enter into, that means they're selling the property.
I didn't suggest that. I said it's an option that could be considered.
Right. And
I'm not recommending that.
But if a hospital, if All Children's Hospital had to enter in a leaseback, that means they're selling a property that they own that they're not currently paying rent on to somebody that's going to charge them rent, right?
But it allows them to keep their cash investments, which you explained were badly needed.
Yeah, well, that's going to decrease their balance sheet in terms of what they have to have going out the door for rent. True?
Correct.
And so, for example, if they had to sell $300 million worth of property and lease it back at, say, 8%, that's gonna cost the company what? How's your math? What, $24 million?
Yeah.
What's the cost of an MRI machine that could survey pediatric cancer and save children's lives?
Objection,
Do you know?
foundation relevance, speculation.
Sustained.
Do you know what the cost? Do you know what that $24 million could go to buy? How many lives could be saved by that?
Same objection.
Sustained.
No more questions.
Any follow-up questions?
No, Your Honor.
Members of the jury, do any of you have any questions? Jury has some questions, sir. Where do punitive damages go?
What do you mean, where do they go?
Do you know who gets them? If you know.
They're paid to the plaintiff.
Next question. Mr. Shapiro mentioned Johns Hopkins All Children's Hospital needs its balances, or that its balances are needed for upgrades, which brings me to ask this. I believe you said Johns Hopkins All Children's Hospital runs about $1.2 billion plus or minus on their tax balance sheets from year to year. Is that correct?
You need to be more specific than that. So if you look at line by line, we only had through 2020 available when I did my analysis. Since that time, like as recently as yesterday, I saw tax returns that were further 2022, for instance. The cash balances stayed fairly stable across all the years. So the argument that Mr. Shapiro made about they need that money to spend, there's no evidence of that in the tax returns. I'm not disputing the fact that he believes that, but the tax returns that I looked at, the cash balances are fairly stable from year to year.
Well, then the next question is, I would believe that Johns Hopkins All Children's Hospital has every year been making constant equipment upgrades, and with constant upgrades still keeps a floating 1.2 plus or minus billion on yearly tax balance sheets.
Again, you have to go into the lines themselves. The cash is the number that if it's the net number of what goes in and what comes out. So if you add the numbers up, it's fairly stable from year to year. So if they're investing in new equipment, which I can imagine they are, every business does, they're taking in sufficient cash to cover those costs.
Okay, thank you. Plaintiffs, any further questions?
Nothing further from the plaintiff for this witness.
Defense.
No, thank you.
Okay, was there any further from the jury?
Actually, I do have one more question.
Come on down, Mr. Shapiro.
Actually, I withdraw. That's fine. Sorry.
May this witness be excused?
Yes, ma'am.
Thank you, sir. And your next witness, please.
For 1 second, session.
Sure. Plaintiffs, are you going to have any other witnesses?
I don't believe so,
So is the plaintiff arrests its punitive damage case?
Yes.
Okay. Members of the jury, we're going to take a few minutes break. You may not discuss this case amongst yourselves. You may not do any investigation. You may not receive any information. Let's go ahead and just take your break, and then we'll call you back and try to, hopefully within 10 minutes or so.
All rise. Jurors exit.
Okay. Please be seated, everybody. Okay, defense, or the jury's out of our presence. Defense, do you have your exhibits that we can talk about?
Yes, I think we're probably gonna use what's in evidence already.
Okay, so we're not going to do any additional exhibits?
I don't believe so, Your Honor.
And did you get those additional clips from the plaintiffs?
Not that I'm aware of, Judge.
They were sent, Your Honor.
They were sent?
I gave Mr. Cottrell the files on their hard drives.
Okay, so what we're going to do is we're going to take a 10-minute break. So if you want to look at those extra clips, you can do that. Mr. Altenberg.
I don't think I have a hard copy of the instruction of the verdict form. I just did the final change on that.
What I'll do is when I come back, I'll bring a copy, and if you can fly spec it. And I think we emailed it, so Mr. Elegant probably would have the ability to look at it as well.
Your Honor, I'm not sure I've seen the one with that one change we made on the verdict form. Let me see. I don't think that's come.
I did not. You're right. I did not resend it after the one change that you made. So in a couple moments, I will resend that, and then I'll bring Mr. Altenberg a paper copy when I come back from break.
Thanks very much.
Okay, anything else before we go on break? Okay, let's try to keep this to no more than 10 minutes, folks.
All rise. Court in recess.
Can you hand Mr. Altenberg? I've got 4 copies of the verdict form and the instructions coming. Where'd all the plaintiff's lawyers go?
Your Honor, do you see Mr.
Well, I have all the plaintiff's lawyers are out, so let's just
Oh, I
wait.
was just asking if my witness was on.
In the waiting room, and I have a Miss Rogers, a Sharon Rogers.
Yes, Your Honor. We were told just before this started that they would not be calling Ms. Green, and that they would only be calling Ms. Rogers.
Well, I have both of them in the waiting room, so
Ms. Rogers will be first.
so you're calling both?
I believe Mr. Hunter doesn't intend to call Ms. Green.
I'm sorry, does or does not?
Yes, does.
Okay. And so everyone now has a copy of the jury instructions and verdict form, and I'm trusting that both plaintiffs and defense will fly spec it again while we are in the defense case. Too much stuff up here. Are we ready to bring the jury back in?
Yes, Your Honor.
From the plaintiffs, are you ready?
We're ready, Jim.
We don't have the jury here. Do you need to approach, or can we just talk?
Let me just talk, I guess. We were given a number of audio
Clips, files.
clips, files, whatever they're. We still haven't been given the video files that we saw the other night. I think you're right. What we got was copies of what Your Honor admitted or ruled upon, and then we got audio, not video. So I think I can proceed with what I've got, Judge, but it's not.
Well, how about this? Can I have everyone's attention from the plaintiff's team?
My apologies.
Why don't we do this? Why don't we start with a defense case? In the interim, the plaintiffs will re-give the video files, and before you rest, Mr. Hunter, I'll send the jury out, and then you can go look at the video files. Does that work?
I guess so, Judge.
Or do you want to?
I'm just concerned that we're going to get blamed for delaying this, given the hour and given the day and where we are. And
Okay. Well, then if you want to do it now, we can do it now, and I'll keep the jury, and the jury won't know. So.
I don't have any objection to what Your Honor's doing, but I do want the opportunity to look at these things, and if indicated to put a clip or 3 in, and we've got a problem with the prejudice that is being inflicted on us, given our position in presenting these things, and the potential perception that a jury that's already not particularly pleased with us is going to blame us for keeping them later.
Well, you tell me, do you want to do it now, or do you want me to send the jury out after you have finished with your 2 witnesses?
I think the 2 witnesses, Judge, we may make the decision that we'll go without. But
And Mr. Altenberg's trying to get in your ear.
I need to see
Did whatever Mr. Altenberg just talked to you change your?
He was asking, and I thought of it, he was asking if I could step out and watch it while Mr. Shapiro is putting the next witness on. And what I told him was that I wanted to see what the next witness said so as not to have overlap with the second witness we're calling.
Understood.
Your Honor,
Yeah.
we had requested to review the 2 boxes of additional materials that were not provided to us at the deposition of Ms. Green. We have yet to receive those.
I thought those were being brought this morning.
They were available here at the courthouse about the time the jury knocked.
So they're still available?
I believe so.
So someone can go out and look at them in the hallway or in one of the witness rooms?
We will do so. If we can know where they are, please.
Where are those boxes?
They're in one of the mediation rooms, Judge.
Do one of
Our
the
paralegals can do it.
paralegals, can you help
Yes.
the plaintiffs? And then from the plaintiff's side, let's talk about those extra clips. Are we getting those in a position so that, I need the plaintiff's attention. Are we getting those clips that were not played here in court? They need to see them,
I
so.
understand. It was nothing intentional. We had some confusion. We are providing the full video clips that we have available.
And how are we doing that?
Mr. Reyes is preparing a thumb drive with the full video clips we received, and he will have it to them momentarily.
Are we ready to bring in the jury at this point?
Yes, Your Honor.
Plaintiffs?
Yes, Your Honor.
Let's bring in the jury. Members of the jury, I want to confirm while you were away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that correct? No one from the media approached you. Is that correct? Or actually, no one, whether they are from the media or elsewise, no one approached you. Is that correct? And you haven't seen any media clips. Is that correct? Defense, your case.
Yes, we call Sharon Rogers, please. She's by video, Your Honor.
Oh, in what state is she in?
She's here in Florida.
Okay. There we go. We'll add the spotlight. And Mr. Cottrell, are you going to be able to? There we go. Good afternoon, Ms. Rogers. This is Judge Carroll. Can you hear me okay?
I can. Can you hear me?
Absolutely, Ms. Rogers. And are you currently within the state of Florida as you sit wherever you're seated?
I am not in the state of Florida.
You're outside the state of Florida?
I am, yes.
Okay. Let me give you an instruction. I am a judge in the state of Florida, so my powers, if you will, only go to the border of the state of Florida. Now, you may allow me to administer the oath to you, but if you allow me to do that, you're going to agree that any sort of action for perjury would actually occur here in Sarasota County, Florida, because that's where you're actually testifying, even though you're not physically here now with us. So understanding that and agreeing to personal jurisdiction here in Sarasota County, Florida, do you agree I can administer the oath to you?
Yes, I agree.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you give is the truth?
Yes, I do.
Okay, go ahead and lower your hand. Thank you very much. And I have Mr. Shapiro in front of me who's going to start the questioning.
Thank you, Your Honor. Can you please introduce yourself to the jury?
Hi, I'm Sharon Rogers.
And what's your current position?
I serve as Vice President and Chief Financial Officer at Johns Hopkins All Children's Hospital.
Okay, I'm going to take you back a little bit. Can you tell me where you got your undergraduate education?
Sure. I attended Indiana University in Bloomington, Indiana.
And what did you graduate with?
Bachelor's degree is in psychology.
Okay. And then did you obtain any other schooling after that?
Yes, my master's degree is also from Indiana University.
And what did you get your master's in?
A master's degree is in information science.
And did you eventually make your way to All Children's Hospital?
I did, yes,
In what year did you start at All Children's?
in 2022.
Okay. And what do you do in your current role?
I have responsibility for our financials.
And when you say financials, what do you mean? If you could explain that a little bit more.
Sure. So I handle financial reporting, budgeting for capital and operating. I work to ensure our teams understand how the financials impact the organization. I work with our executive teams to help connect help ensure our financial decisions are grounded in data, and produce operating statistics for the organization.
Is All Children's Hospital a charitable foundation?
We have a charitable foundation.
In terms of your filing, how is All Children's organized? Maybe if you could explain what a 501c3 is.
Yes, we are a nonprofit organization, so we are here to provide care for the community. We are here to provide care for all members of the community. Of course, we're focused around pediatrics. We provide care for anyone who needs our care, regardless of payer or ability to pay.
Let me talk to you a little bit about that. Are you generally familiar with what the payer sources are for the children that you serve?
Yes, I am. Our payer sources, many are familiar that there are multiple types of payer sources, government and non-government. We are 61% Medicaid as our payer source, 35% commercial, 1% self-pay, and 3% other.
So in terms of Medicaid, the majority of the children treated at All Children's are Medicaid funded. Is that correct?
That's correct.
Okay. So when you're dealing with a Medicaid patient, are the reimbursement rates from Medicaid sufficient to pay the expenses that All Children's incurring to pay for them?
They are not. Medicaid is by far the most challenging payer. Does not cover the cost of providing care. That is pretty well known across the industry. So Medicaid covers roughly 70% or 70 cents on the dollar for the care that we provide. And given it's 61% of our payer mix, that has a significant impact on us.
So what happens if a child in need of medical care comes into All Children's with Medicaid? Do you still treat them?
Oh, absolutely. Yes.
And what if there are medications that the child needs that Medicaid doesn't cover? Do you still provide them?
We provide medications. Yes.
And where do you come up with that revenue if you're losing money on that?
We, all hospitals do their best. We are very uniquely poised because we have such a high Medicaid population. So we have fairly narrow margins. We, try to very efficient with our teams using industry best practices. We do our best to be efficient and resourceful to ensure that we can provide care for all patients who are coming in need and are in need of our care.
Let me ask you a little bit about a document that was shown to the prior witness. Do you have the 990 tax return in front of you, Ms. Rogers?
I do, yes.
I'll put it up on the screen. It's Trial Exhibit 2279H. And for your purposes, Ms. Rogers, I'm going to turn to the second page. We'll put it on the screen as well. I want it 2279H-002.
Okay. Sorry, I had not enabled Mr. Cottrell to do that, so
Okay.
that was my fault. I'm sorry.
No problem. Can you enlarge that a little bit, Clay? Okay, and scroll down a little bit. There's total revenue lines. You see at line 12 the revenue for the year. Are you able to see that, the 544?
Okay.
Yeah.
Yes, I see it now. Yes.
Okay. And there's for the prior year and the current year. Do you see that?
Yes.
And then, for example, in the prior year of this tax return, what was the revenue?
Prior year's revenue was $544 million.
And what,
$193.
and what were the expenses?
Prior year's total expenses, $563 million.
So did the hospital run a shortfall on revenue in the prior year of 2020 of almost 19 million?
Yes.
And was that the year, that was COVID, is that right?
The prior year was the start of COVID.
Okay. But the hospital keeps its doors open even though they had outspent what they took in. How do you do that? Do you tap into reserves or what's the function?
Yes. So the hospital kept its doors open. We did have to tap into reserves during the early period of COVID. We continued to provide care for the community. There were a lot of expense increases, not only in the early days, but especially in the periods following COVID. Volumes dropped significantly. So there were a lot of adjustments that had to be made, not only in the beginning of COVID, but a lot of adjustments had to be made afterward as well.
Let me ask you about the line 8, contributions and grants. What is that?
That represents primarily two items, one being a Healthy Start, which is a grant that's received, but in large part, it is provider relief funds, which is our CARES Act, which is a federally provided fund that was given to many hospitals across the country to help support the period of the pandemic.
Did that CARES Act money, that $33.447 million, did that continue into this year or is that now gone?
That is now gone.
So that was a one-time funding from the federal government during the period of COVID?
That's correct.
Let me ask you a little bit about the capital, the $19 million in capital that's spent. And you can take that down for now, Clay. What does it mean to spend money on capital improvement?
Sure. So like any large organization, you want to reinvest in the organization in order to keep up with routine maintenance, not only with routine maintenance, but you want to also be able to strategically invest. In most organizations, you want to be able to keep up with the rate of depreciation. We spent $19 million in capital this year, in the year that you're talking about. That does not keep up with the rate of depreciation. That was to handle some general routine maintenance. You want to make sure that everything from roofs to HVAC systems to elevator equipment, that you are keeping up with those things so that you don't get into problems down the line.
Okay. That money is used to ensure safety at the hospital. Is that right?
That's exactly right.
Now, in terms of the jury has seen that there's about $500 million in potential investments that the hospital keeps on its balance sheets. Can you tell the jury what's that for?
Sure. So any large organization needs to have a healthy balance sheet. We are no different from needing to have a healthy balance sheet. That balance sheet and those investments are, well, one, having a healthy balance sheet is important. Creditors look at that. If we are going to borrow They want to ensure that we are fiscally sound. Having a healthy, having access to investments allows us to continue to provide care to the community that helps us uphold our mission. So not only those routine investments, strategic capital investments, but large strategic investments are really important. Every dollar that we have really needs to go back into the community. So that available investment pool is there for that purpose.
What happens if that amount gets depleted? Meaning, does that affect your ability to borrow money or credit rating agencies? Can you explain that, please?
Yes, if that money is depleted, that affects our credit rating agency. Absolutely, it affects us in the case of an emergency. I mentioned that during the period of the pandemic, we had to access and tap into that pool because of the emergency period that we were in. We wouldn't have access to that. Also, projects that are growing and extending our care to the children of our community who need us. That money is there for them, for those strategic growth projects that would allow us to expand our care.
Do you have outreach clinics in Sarasota?
Yes.
And if you know, do those operate at a profit or a loss?
So our clinics generally operate at a loss. This is pretty consistent where clinics operate at a loss.
May we approach these lines of questioning?
Approach. Ms. Rogers, I'm going to turn off.
You can unmute, Ms. Rogers.
I've got to open up the microphones again. Ms. Rogers, go ahead and unmute yourself, please. Can you hear me okay now, ma'am?
I can. Can you hear me?
Yes, absolutely. Mr. Shapiro, you may continue.
Sure. In the year, for example, 2020, 2021, did the clinics in the outreach clinics like those in Sarasota operate at a loss?
Yes.
And where does the shortfall come from? Does that come from the hospital?
Yes, it's made up by the hospital.
Okay. Let me turn back to some of the sources of revenue at the hospital that may cover that shortfall. Well, let me ask you if you know, just to cover this. Do you know what the largest source of funding is in terms of program?
Our NICU is our largest source. We care for many of the most critically acute or sickest children in our community, and our NICU is by far the largest program and revenue source.
And we're all familiar, at least with the acronym. That's the neonatal intensive care unit?
Yes, sir.
Is that, if you're familiar, is that where babies go when they're struggling to breathe after birth?
Yes, sir.
Okay. And do you know, in terms of acuity, where All Children's ranks, at least state, local, in terms of what our All Children's acuity is versus other hospitals?
Objection, foundation,
Yes.
relevance.
Overruled.
You can answer.
We care for the sickest or the most acute babies in the state of Florida.
Okay. What about respiratory therapy? Is that another category that is one of the larger programs?
Yes, it is.
Okay. And what types of services does that cover?
Respiratory therapy is helping. It is also helping ensure that our patients and children can breathe effectively, and caring for inpatients in the hospital.
Do you know what comes next in terms of the order of funding sources, programs?
Our surgical care program is a very strong program as well.
Does that include both surgery for kids? Does that include children born in the neonatal intensive care unit?
Yes. Yes, it does.
Does that include children that have been afflicted with cancer and need surgery?
Yes, it does.
And are those programs, from your knowledge in terms of strategic planning, that All Children's is looking to expand if they have the resources to do so?
Yes, absolutely.
And do children, both those who are born with cancer and those who are born with congenital anomalies down in Sarasota, do you serve that population?
Yes, we do.
And do you provide outpatient clinics to make it easier for people in the Sarasota area to access your services?
Yes, we do. It's important for us that we are providing care to our patients close to where they reside.
Let me talk to you about the concept of money being fungible. Do you know what that means?
Yes, I believe I know what you're referring to.
So let me try to break it down. Every dollar that's spent on something, you have a pool of money. You can either spend it on patient care operations or you can spend it on something else. Is that right?
Yes.
Okay. So just to be clear, the money that's left over at the end of the year, is it reinvested back into the organization?
Yes.
Yes. And the money that's reinvested back into the organization, does it go into strategic planning to help sick children in the community, including those who have cancer, those who are born with congenital anomalies? Is that true?
Yes.
And
yes, it does.
we heard, you weren't here for it, but the concept of, well, All Children's could just sell land and lease it back. Are you generally familiar of like sale leasebacks and what that entails?
I'm familiar with that concept.
That would cost All Children's money if they had to sell property and then lease it. Well, let me ask you: Would it lead to All Children's having a negative cash flow situation relative to where you are now if you had to sell property and lease it back to yourself?
Objection, leading, vague, ambiguous.
Overruled. She can answer.
It would. That would take funds out of our operating income if we had to pursue that option.
And when you say operating income, the number one goal of the operating income is to provide.
Objection, leading.
Let me just ask you, what is the goal of the operating income?
Well, the goal is to ensure that we have money to be able to provide care to fulfill our mission, which includes caring for the community's most vulnerable children throughout the community. And that extends from sick children to, research, providing innovative care, ensuring access to drugs and therapies. As well as those capital routine maintenance capital projects that I mentioned in strategic projects.
When you talk about strategic projects, as the CFO, does All Children's have the revenue right now to fund them all?
No, we don't. We have historically underspent on some of our capital needs and are assessing those now. Of course, keeping safety first, and have pursued the items that we absolutely need to. But there is a lot on the list of things that we both need and want to do that has not been pursued.
If All Children's were required to pay a punitive award in this case where the money left the hospital, would that cause you as a CFO to go to the strategic planning committee and tell them there are certain projects where you're trying to save lives in the community that now need to go on hold?
Yes, it would put a stop to those plans.
One moment, Your Honor.
Cross-examination.
Yes, sir. Good afternoon, Ms. Rogers.
Good afternoon.
Thank you for joining us on short notice. Where are you physically today?
I'm in Indiana today.
Understood. Does Johns Hopkins have a hospital in Indiana?
No, they don't.
I'm curious to know who writes or who you're employed by. Is it Johns Hopkins All Children's Hospital or the system?
I'm employed by Johns Hopkins All Children's Hospital.
Understood. I want to discuss with you and this shouldn't take long. I want to discuss with you the tax returns that are in evidence. And I want to begin with what's been marked as 2279 Hotel. Mr. Reyes, if you could please publish or share 2279 Hotel. One moment, Ms. Rogers, just dealing with the technology. By the way, Ms. Rogers, while we're waiting for that, were you scheduled to attend a deposition at 1 o'clock this afternoon?
Yes, I attended and then was told that it was put on hold.
Understood. So you and I have not had an opportunity. I'm sorry. You and I have not had an opportunity to speak before, have we?
No.
Are we close? Ms. Rogers, while we're 2279 Hotel. While we're pulling that up, do you also have in front of you there the fiscal year 22 Form 990?
Yes.
Is there a fiscal year 23 Form 990 that's been filed yet?
'23?
Yes, ma'am.
Not yet.
If I understand correctly, the fiscal year for Johns Hopkins All Children's Hospital ends on June 30th each year. Is that right?
That's correct.
And so, just out of curiosity, what month is the latest fiscal year's tax return typically filed?
It is typically, you'll have to excuse me, because I will have to check. I am newer to the organization, so I don't know the typical month. I know we're finishing our audit for fiscal year 23 at the moment.
Understood. And yeah, thank you for reminding me of that. You joined Johns Hopkins All Children's Hospital last year.
Beginning of last year, yes.
All right. And so you weren't around when the 2021 tax return was prepared, or the 2020, right? Ma'am?
I was in place to acknowledge it and review the 2021.
Oh, you were? All right. All right, turning to what's in front of you, and can you see the tax return on your screen, ma'am?
Yes.
All right. If we would turn to the next page. And Mr. Reyes, if you would focus in on line 19 here. If you could zoom in on line 19, please. Do you see line 19, ma'am?
I do.
And so the $19 million loss that you discussed with Mr. Shapiro there, that was the prior year, correct?
That's correct.
And you discussed the loss at some length, but the next year, the hospital had a profit of $36 million, right?
That's correct.
And if we turned to the 2021 form, which would have been filed in 2022, just keep this here for now. The next year, you had a profit of $31 million, correct?
Yes, 30.8 million, yes.
And so that year that we saw there in the 3-year trend that we have is the outlier, the loss of $19 million, right?
You have to consider it is not, if you went back to the prior year, the year before, the one that's shown with the negative 18, you would see an even more significant loss than that listed. And you have to factor in the one-time receipts of the CARES Act, the Provider Relief Act funds that we received during this period.
For the 2 most recent years on file, Johns Hopkins All Children's Hospital had profits of $36 million and then $31 million. Am I correct?
Yes, we received over $60 million in provider relief funds.
So the 2 most recent years on file, Johns Hopkins All Children's Hospital has been profitable. Correct?
Correct, with the inclusion of the provider relief funds.
Understood. And the hospital wouldn't end up with a $600 million cash accounts and cash equivalent balance if it had been operating at a loss over its history, would it?
No, not if you look at the history in total.
All right.
If we look at the recent year's performance, the hospital has had very challenging years, which and you would see that the operating margin has been very much challenged.
So $30 million profit and $35 million profit, you would characterize those as challenging years?
Yes, absolutely, because the revenue that is leading to that bottom line there is a one-time, not something that's sustainable. And so, like with any of our families or home situations, we want to be able to have income that we can depend on. And those one-time provider relief funds and CARES Act payments aren't something that we can continue to rely upon into the future. Those were temporary infusions that we received during the pandemic, which was obviously an outlier period. So those are very unique circumstances.
I'll move to strike the answer to the extent it was non-responsive.
Overruled.
Ma'am, over the history of Johns Hopkins All Children's Hospital, it has on more years operated at a profit, leading to a $600 million cash and cash equivalents balance as of 2020, correct?
Well, to clarify, when you speak to the history, the entire history of the hospital, I can't go back to the entire history of the hospital. But when we're looking at our recent performance and decisions that we're making now based on our current operating margin, we have to look at how we're performing right now and how we performed in recent years in order to determine what decisions we're making now and what free cash flow looks like right now. And that's been challenged.
Mr. Reyes, if you could turn to this same document, what Mr. Heath referenced, which was labeled in the top corner, page 9. And I think that's page 11 or 12 in actuality. Perfect. Nope. I see that. Can you scroll forward and back a couple pages? I'm not sure. Next. Back. Why is this not matching up? May I have a moment, Your Honor?
Sure.
If you could display that page, please. My apologies, Ms. Rogers. All right. You recognize this as the All Children's balance sheet as reported in 2021?
Yes.
And is it accurate that after factoring in depreciation, the book value of the land, buildings, and equipment held by Johns Hopkins All Children's Hospital was $400 million, just under $400 million as of 2021?
Yes.
And would you agree with me that if you look at the figure $651 million and change, that the $400 million we see reflected in terms of book value of the real estate significantly underestimates the market value of land, buildings, equipment as of 2021?
I can't speak to that.
You'd agree with me that the value before factoring in depreciation was $652 million approximately?
Your question is?
My question is, ma'am, in box 10A, before you factor in depreciation, which is a tax concept, is it not?
It is.
That the value of the buildings, equipment, and land was $652 million before depreciation.
Yes.
Have you, since you've been at Johns Hopkins All Children's Hospital, has the hospital had the value of its real estate, including land, buildings, and equipment, appraised?
In total, I would have to verify I would have to verify that. I'd have to defer to our operations team.
Do you have an estimate of the?
In about every single piece of land, I'd have to validate that.
But in your role as CFO, do you have a rough estimate of the appraised value, market value, of the land, buildings, and equipment currently held by Johns Hopkins All Children's Hospital?
I would prefer not to provide a rough estimate.
Why is that?
I don't have a rough estimate to provide to you.
You're not familiar? All right. Moving on. Line 11, publicly traded securities. It's accurate that as of 2021, Johns Hopkins All Children's Hospital held approximately $518 million in publicly traded securities?
That's correct.
What are the top 5 holdings of Johns Hopkins All Children's Hospital in terms of public securities?
I'd need to validate that.
Would they be Dow stocks like we would expect, Apple, Google, Microsoft, et cetera?
No, we have complex, we have, just like any organization, we have investment portfolios that are managed. So it's not individual stocks.
Are you aware, even through your investment vehicles, what the top 5 holdings of publicly traded securities are?
No, not with individual companies.
If we look at the category of investments program related, and I see $24,265,000, what are we talking about there?
On
line 13, ma'am.
Okay, that is I apologize. Those are our board designated investment holdings.
Can you give us an example or two?
I'm not sure what you're looking for.
Oh, well, you just mentioned they were board-directed investment holdings. I was wondering if you could give us what those would be in concrete terms. What does that mean? What are they?
No, I don't have the names of the funds.
And then
I don't have the names of the funds written.
Understood. And line 15, other assets of $46 million. Do you see line 15, Ms. Rogers?
Yes.
Well,
And I'm sorry, 13, those are board designated funds used that's for the debt service.
Understood.
So those are for debt service.
And then $46 million on line 15, other assets. Do you see that, Ms. Rogers?
Yes.
What are we talking about there? What types of other assets?
That is lease, right of use, prepaid inventory.
Are you finished with your answer, ma'am?
Yes.
All right. And would you agree with me that as of the filing date here of June 30th, 2021, Johns Hopkins All Children's Hospital held total assets of $1,163 million and change?
Total assets, yes.
Nothing further this time.
As reported there.
Nothing further this time. Thank you.
Any redirect?
Briefly. Ms. Rogers, you there?
Yes.
Okay. When Mr. Whitney was asking about income of 36 million and 31 million, that all goes back into the hospital. It's not distributed as profit,
Objection,
correct?
meeting.
Overruled.
That's correct.
And so, in other words, if All Children's is able to operate at a profit, they take the money back and devote it back into patient care in the community. Is that right?
Yes, all of the money goes back into the hospital in order to expand programs, extend programs, compensate team members, compensate providers. All of the money stays within the hospital. Goes back into patients.
And every dollar that you don't have available, whether it goes out in a punitive damages award or otherwise, is the dollar that All Children's does not have to fund patient care, including helping children struggling to breathe in a neonatal ICU, children with cancer. Is that true?
That is true, yes.
Thank you.
Anything further, Mr. Whitney?
No, Your Honor.
Hold on a second, Ms. Rogers. Let me see if the jury has any questions. There's going to be a jury question, so just hang tight. Ms. Rogers, I'm going to mute your microphone. Okay.
Ms. Rogers,
If we could go ahead and have you unmute. Are you able to hear me?
I can.
There's a series of questions. Based on what I heard Mr. Shapiro comment on about the 2020 Johns Hopkins All Children's Hospital tax return, which is the only tax return this jury has been allowed to view, in 2020, you basically lost money between what you took in and then what your expenses were. Is that correct?
Between 2020, yes.
You pointed out that this was a COVID area year. Therefore, your income was not that of the non-COVID years. Is that my understanding of what I believe you were stating?
Can I restate your question to make sure I'm...
Yes, you may.
Okay. So this was a COVID era. So this was, our income was not what we were used to. That is not exactly correct. We are not a hospital that has high margins in a normal year. Because of our challenging payer mix, we are not a hospital that has a benefit of having large margins in a normal year. The COVID period made things even more challenging for us because of all of the challenges that came with the pandemic. During COVID, we received a one-time payout that hospitals across the country received to help during that period. So that number is represented in the financial statements for those COVID years.
Okay. Next question. Are you saying that Johns Hopkins All Children's Hospital is forever operating in the, quote, financial red, end quote, and never makes enough money for upgrades to better your programs, surgical rooms, or even research?
Not forever, but for the past 5 years, three of those 4 years, 3 of those 4 years without the provider relief funds have been negative. And the one that wasn't, it was less than 1% margin. So very narrow margins. Which means we have to tap into other sources.
A 501c3 is a nonprofit, but by no means does it mean that it cannot make money. I see just 1 year's tax balance sheet, and Johns Hopkins All Children's Hospital carry balance and assets, at least in the COVID bad income year 2020, about $1.2 billion. So am I correct that nonprofit does not mean no money?
Correct. Nonprofit doesn't mean that an organization isn't allowed to have funds available. Those funds are used to be able to expand and extend the mission of the organization. And it is the intent of those funds to be able to deliver upon the mission. That's the purpose of those funds.
You mentioned that every dollar goes to pay for items and it goes back into the hospital. But Johns Hopkins All Children's Hospital does have, for just the 2020 tax file, in cash, securities, and assets, about $1.2 billion saved up in various forms that Johns Hopkins All Children's Hospital declared on federal taxes. So not everything goes back into the bill. Am I correct?
So the 1.2 billion that is on the balance sheet, that is not available. That includes buildings and lots of other assets that aren't accessible. It includes many different things. There are some. There is a portion of that is for strategic investments.
Mr. Shapiro, do you have any further questions of this witness?
Yeah. Just briefly, so the cash, if you have a shortfall, then you can tap into those reserves. Is that right?
That's correct.
Okay. And again, whether you have a profit of, 1 million or 33 million, or if it's a good year and it's a little higher, when you think of profit, all of that money goes back into saving children's lives in this community. Is that true?
Yes.
That's
it all goes to advance our mission.
Mr. Whitney, anything further?
No, Your Honor.
Do the jurors have more questions? And Ms. Rogers, if you can unmute your microphone. Members of the jury, I'm not going to be able to ask that last question. Mr. Shapiro, do you have any further questions?
No, thank you, Your Honor.
Mr. Whitney, anything further? No. Okay, Ms. Rogers, thank you very much for being here.
Thank you.
Okay, members of the jury, what we're going to do is we're going to take a 10 to 15 minute break. I'm going to ask the court deputies to take your dinner order at this time. So it's going to take us a little bit longer for this break. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. We'll call you back in 10 to 15 minutes.
All rise. For the next step.
Seat, is there anything we need to address before we take our 10-minute break?
The only thing I want to bring to your attention, Your Honor, is it occurred to me, in this unusual situation, I need to move for a directed verdict on specific intent. I would, if had it been pled and proved in the front end, I would have moved for it at the end of their case and at the end of all the evidence. But before this goes to the jury, I think I need to make the argument that they've never proved the evidence required for specific intent on any of these claims.
Okay, what I'll do is I'll take it under advisement. I'm going to allow it to go to the jury, but I will keep it under advisement, okay?
Thank you.
Okay, 10-minute break.
All rise. Court's in recess.
Slow on my latest amendment, but
What's that?
Did you object to it?
Has Mr. Altenburn seen this?
I have no idea what you're talking about.
Yeah. I object to the question,
Instruction.
or the instruction. Yeah.
Goes to Maya Kowalski. She can do whatever with it she wants to. That's the law.
yeah, but the problem,
So, but
So
Mr.
if
Shapiro
the
is,
person says it goes to her and she can do whatever she wants with it.
so the question is, Mr. Shapiro wanted to object to the instruction, and
Yes, we object to it.
court's going to agree with the defense, and I will not give that instruction, or let me just say not give it.
Judge, we're going to, we've taken a quick glance at what's been sent us, and we've reviewed the situation in which we are, and discussed it in as much detail as time will permit. So we are going to rest at this point under the circumstances.
So you're not going to call the,
Correct.
that person's no longer in my Zoom queue, so
She was
told?
She was very, well,
Okay, it doesn't matter.
she's left.
Now, you looked at those extra video clips. Did you want
We
to?
can't edit those things in time to do any good with them, Judge, and it would take time to get that done, time that we believe would be prejudicial to us to do at this point. And the time situation and the situation in which we find ourselves in that regard is part of is the major force behind this decision. If it weren't this hour, if it weren't this situation, we might feel differently. But editing the clips in the way we want to do them would take upwards of 30 to 45 minutes, from what I can tell at least. And we're just not in a position to do that with where we are on this evening in this situation.
Well, I'm giving you the opportunity to edit the clips if you wish to edit the clips. So that's going to be your decision whether you want to do that or not.
I understand, Judge. What I'm telling you is we're all watching the same jury. We're all watching the same reactions. And I think you understand what I'm saying.
So if the defense is going to rest, is that going to end our evidence?
no, Judge, we're resting too. We can go on to closing.
Okay, so that ends our evidence.
That ends our evidence.
Both Mr. Anderson and I anticipate brief closings.
Now, then, before we bring the jury back, and this goes to Mr. Altenburn and Mr. Elegant, have you reviewed the jury instructions in the verdict form? And again, I am saying that I understand the defense is objecting to the specific intent instructions and do not want them, and I have overruled that. So,
And you've reserved ruling on my directed verdict motions, and so the question is, are these consistent with your rulings? And I see nothing that needs to be changed that would make these inconsistent with your rulings.
you said it much more eloquently than I could, Mr. Altenburn. Thank you. Mr. Elegant, anything relative to the jury instructions?
No, there were a couple negatives in there, but they look good to me, Your Honor. I think you've done what you said you were going to do, and that works.
Now, is the plan that I'm going to read the jury instructions and go over the verdict form and then closing arguments? Is that the plan?
I would request that.
Yes, either way, Judge. I'm used to it either way, so whatever the court's preference.
And I think I've given you all the paper verdict forms. I just had an extra one. let me hand one of these instructions to the court reporter. And Madam Court Reporter, do you need a copy of the verdict form as well? So this will go to the jury. Okay, let's go get the jury and bring them in. Please be seated, everyone.
Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that correct? And no one approached you about this case. Is that correct? And you did not see any media accounts of this case. Is that correct? Okay. Defense, do you have any more witnesses you'd like to call? Any more witnesses from the plaintiffs?
We rest, Your Honor.
Okay. Members of the jury, I'm going to have the court deputy hand each of you a copy of the jury instructions for Phase 2. And didn't either Mr. Reyes or Mr. Cottrell get a copy of them so they can publish them, or are we just going to not? I know we sent them to the team. I just don't know if they got them to you. I'm sorry? There we go. Someone has them. Thank you. Whoever has it.
Mr. Cottrell, thank you very much, sir. Okay, members of the jury, you can listen to me or read along and listen to me at the same time, whichever you'd like to do. Members of the jury, I am now going to tell you about the rules of law that apply when you determine whether punitive damages should be assessed, and if so, in what amount. When I finish with these instructions, the parties, well, I apologize, I should have read this earlier. You will consider the additional evidence along with the evidence presented, and you should decide any disputed factual issues by either the greater weight of the evidence or by clear and convincing evidence as specified on the verdict form. Greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case. Clear and convincing evidence differs from the greater weight of the evidence in that it is more compelling and persuasive. Clear and convincing evidence is evidence that is precise, explicit, lacking in confusion, and of such weight that it produces a firm belief or conviction without hesitation about the matter in issue. You are to decide the amount of punitive damages, if any, to be assessed as punishment against Johns Hopkins All Children's Hospital and as a deterrent to others. This amount would be in addition to the compensatory damages you have previously awarded. In making this determination, you should consider the following. A, the nature, extent, and degree of misconduct and the related circumstances, including the following. 1, whether the wrongful conduct was motivated solely by unreasonable financial gain. 2, whether the unreasonably dangerous nature of the conduct, together with the high likelihood of injury resulting from the conduct, was actually known by the managing agent, director, officer, or other person responsible for making policy decisions on behalf of Johns Hopkins All Children's Hospital. 3, whether at the time of the loss, injury, or damage to Maya Kowalski, the managing agent, director, officer, or other person responsible for making policy decisions on behalf of Johns Hopkins Hospital had a specific intent to harm Maya Kowalski, and whether the conduct of a managing agent, director, officer, or other person responsible for making policy decisions on behalf of Johns Hopkins All Children's Hospital did in fact harm Maya Kowalski. And B, the financial resources of Johns Hopkins All Children's Hospital. However, you may not award an amount that would financially destroy Johns Hopkins All Children's Hospital. You may, in your discretion, decline to assess punitive damages. Now that you have heard and received all the evidence on the issue of punitive damages, You have now heard and received all the evidence on the issue of punitive damages. Your verdict on the issues raised by the punitive damages claim of Maya Kowalski against Johns Hopkins All Children's Hospital must be based on the evidence that has been received during the trial of the first phase of this case and on the evidence that has been received in these proceedings and the law on which I have instructed you. In reaching your verdict, you are not to be swayed from the performance of your duty by prejudice or sympathy for or against any party. Your verdict must be unanimous. That is, your verdict must be agreed to by each of you. You will be given a form of verdict, which I will now read to you. And Mr. Cottrell, do you have those that you can, the verdict form? Okay. We, the jury, return the following verdict in regard to the punitive damages. For Claim 1A, false imprisonment between October 7 and October 13, 2016, Maya Kowalski. Question 1. What is the total amount of punitive damages, if any, which you find by the greater weight of the evidence should be assessed against Johns Hopkins All Children's Hospital for the false imprisonment of Maya Kowalski occurring between October 7 and October 13, 2016? Now, the form tells you what to do. If you elect to assess punitive damages against Johns Hopkins All Children's Hospital for this claim, please write the amount on the line immediately below and then answer question 2. If you elect not to assess punitive damages against Johns Hopkins All Children's Hospital for this claim, you should enter a 0 as the amount of damages, skip questions 2 and 3, and answer question 4. And there's the line if you elect to assess punitive damages. Question 2. Do you find by clear and convincing evidence that at the time of the false imprisonment of Maya Kowalski between October 7th and October 13th, 2016, did Johns Hopkins All Children's Hospital have a specific intent to harm Maya Kowalski? And did the conduct of Johns Hopkins All Children's Hospital in fact harm Maya Kowalski? You will answer that either yes or no. The form tells you what to do next. If your answer to question 2 is yes, you will skip question 3 and then proceed to question 4. If your answer to question 2 is no, you will answer question 3. Question 3. Do you find by the greater weight of the evidence that at the time of the false imprisonment of Maya Kowalski between October 7 and October 13, 2016, did Johns Hopkins All Children's Hospital have a specific intent to harm Maya Kowalski, and did the conduct of Johns Hopkins All Children's Hospital in fact harm Maya Kowalski? You will answer that either yes or no. The form tells you to go to question 4. This is claim 1B, false imprisonment between October 18th and October 20th, 2016 for Maya Kowalski. Question 4. What is the total amount of punitive damages, if any, which you find by the greater weight of the evidence should be assessed against Johns Hopkins All Children's Hospital for the false imprisonment of Maya Kowalski occurring between October 18th and October 20th, 2016? The form tells you what to do next. If you elect to assess punitive damages against Johns Hopkins All Children's Hospital for this claim, please write the amount on the line immediately below and then answer question 5. If you elect not to assess punitive damages against Johns Hopkins All Children's Hospital for this claim, you should enter a 0 as the amount of damages. You will skip questions 5 and 6, and you will answer question 7. Question 5. Do you find by clear and convincing evidence that at the time of the false imprisonment of Maya Kowalski between October 18th and October 20th, 2016, did Johns Hopkins All Children's Hospital have a specific intent to harm Maya Kowalski? And did the conduct of Johns Hopkins All Children's Hospital in fact harm Maya Kowalski? You will answer that either yes or no. The form tells you what to do next. If your answer to question 5 is yes, you will skip question 6 and go to and answer question 7. If your answer to question 5 is no, please answer question 6. 6. Do you find by the greater weight of the evidence that at the time of the false imprisonment of Maya Kowalski between October 18th and October 20th, 2016, did Johns Hopkins All Children's Hospital have a specific intent to harm Maya Kowalski, and did the conduct of Johns Hopkins All Children's Hospital in fact harm Maya Kowalski? You will answer that either yes or no. Please answer question 7. Now, question 7 deals with claim 1C and claim 2 combined. That's the false imprisonment and battery on January 6, 2017. So they will be handled together. Question 7. What is the amount of punitive damages, if any, which you find by the greater weight of the evidence should be assessed against Johns Hopkins All Children's Hospital for the false imprisonment and battery of Maya Kowalski occurring on January 6, 2017? The form tells you what to do next. If you elect to assess punitive damages against Johns Hopkins All Children's Hospital for this claim, please write the amount on the line immediately below and answer question 7. If you elect not to assess punitive damages against Johns Hopkins All Children's Hospital for this claim, you should enter a 0 as the amount of damages, skip questions 8 and 9. The verdict form in that case would be complete. The foreperson must sign and date the verdict form on page 7. Question 8. Do you find by clear and convincing evidence that at the time of the false imprisonment and battery of Maya Kowalski occurring on January 6, 2017, did Johns Hopkins All Children's Hospital have a specific intent to harm Maya Kowalski, and did the conduct of Johns Hopkins All Children's Hospital in fact harm Maya Kowalski? You will answer that either yes or no, and the form tells you what to do. If your answer to question 8 is yes, you will skip question 9 and your verdict is complete. The foreperson must sign and date the verdict form. If your answer to question 8 is no, please answer question 9. Do you find by the greater weight of the evidence that at the time of the false imprisonment and battery of Maya Kowalski occurring on January 6, 2017, did Johns Hopkins All Children's Hospital have a specific intent to harm Maya Kowalski, and did the conduct of Johns Hopkins All Children's Hospital in fact harm Maya Kowalski? You will answer that as yes or no. The verdict form is now complete. The foreperson must date and sign the verdict form. Okay. Now we are going to proceed into closing arguments. Again, each side has the same amount of time. The plaintiff will be able to reserve a few minutes of that time to proceed after the defense has finished its arguments. Who's going to make the argument on behalf of plaintiff? And are you seeking to reserve any time for rebuttal?
I'm going to take 4 minutes and then 1 minute.
Okay. There you go.
You're all tired, and you get it. The problem is they don't. I thought they were going to get up here and explain how much money they had expended in order to correct the cultural problems and all of the internal issues that led to what happened here. But they didn't come up and tell you that. And I got a little upset, I have to tell you, when they started talking about all the lives they were going to save, when I kept thinking to myself, where were the efforts to save Beata? So let's cut to the chase here. This was a company in immediate jeopardy. you have access to all of the prior evidence. You don't just take what's in here. You can take all the evidence that you had before, which is why I was mentioning the email chains to indicate the direct line up from Jackie Crane, who's number 2 in this place, right up there next to the CEO, across to risk management and straight down to Kathy Beatty, who is the implementer of all that. That's about as specific of an intent as you can because it's directed to Maya. So now, how do you do it? Well, there's a number of questions again about specific intent as to each one of these. You all talk and consider the evidence there. One other thing as to specific intent, consider the aftermath and the entire ketamine girl exchanges. Just think about that when you're discussing.
This is not punitive damage argument, Your Honor. It's
Overruled. Now, there's $600,000.
I also object because it doesn't go to false.
$600 million.
Hold on a second.
It doesn't go to false imprisonment or battery, Your Honor.
I will actually sustain that the claims for punitive damages are in battery and false imprisonment as to Maya Kowalski and not as to anything having to do with wrongful death as it relates to Beata Kowalski.
I understand, Judge. I understand. That
Okay,
was my intent with that one.
The jury is going to disregard the argument with respect to Beata Kowalski.
So here's what you've got: $600 million in cash and cash equivalents, and then you've got $1.2 billion in the total assets. So my suggestion is this: there's 3 questions there, 3 different incidents. One's combined, and you can assign percentages. But I suggest again that you come up with a total number, and then go back and for your incidents, then based on what you think in terms of egregiousness, you assign a percentage.
I object to the lump sum calculation being divided by a percentage as improper.
If I could get it out and explain it, Judge.
Okay, sustain the objection.
So what you have is you can then take either $600 million or the $1.2 billion and decide what percentage of that spread among the
Same
amount
objection,
you
Your
decide
Honor.
for each one. That's the
Sustained.
only way to do it.
Sustained.
I think you understand what I mean. So the numbers are $600 million or $1.2 billion.
Same objection.
Coming out of that.
Also, I object because those numbers would bankrupt the hospital, which is what.
Speaking objection is not.
Okay, I agree with no speaking objections. I'm overruling the objection, and you can have your own argument when Mr. Anderson's complete. And it appears he's complete for now.
Okay, thank you, Your Honor. I know it's late, so we'll try to get to the point with y'all, I promise. Again, these damages are to punish and deter, and if your anger is at Kathy Beatty, she's not there. I think you heard from Mr. Corcoran, and I'll just be brief on this, that whatever the emergency problem was in 2019 was immediately corrected. He was complimentary of the hospital getting it on the right ship after that. That's undisputed testimony from Mr. Corcoran that the corrective action plans were made immediately. So there's nothing to punish and deter from what happened in 2016. I just want to talk to you about a couple of quick concepts. Some of these findings, in fact, most of them, require a specific intent to harm. And I would just ask you to go back to some of the evidence you heard for 9 weeks. Was there really a specific intent to harm Maya when they were asking the family to stay at the hospital? I know you disagreed with it. I get it. Okay, you wouldn't have checked the box saying there was false imprisonment if you thought that all children's, for whatever conduct it was, wanted them to stay, put pressure on them to stay, whatever it was you found, and I don't have a chance to interview individually. But I would just ask you to go back and put yourself, I would ask you to go back and consider the evidence of healthcare providers that were presented with a situation where they were told that Maya Kowalski was given an amount of ketamine that was 200 times what their protocol was, that they saw her in withdrawal, that Beata Kowalski was asking for intrathecal clonidine pumps that Dr. Santana told you could be lethal, that they were asking for ketamine comas that are legal in the United States. It caused them alarm. It caused them alarm. There was never an intent to harm Maya Kowalski. There was never an intent in that week period. They were trying to do what they thought they could do to protect Maya. I know you disagree with it, but I'm really hoping in your hearts you don't think they were trying to harm this child in that week. The reason why they wanted her to stay was because they thought they could help her and thought they could get her on the right course. I would ask that since your verdict in this is going to be, it's to punish and deter, is that the effect that you want of healthcare providers who've dedicated their lives to medicine to be muzzled, where they are afraid that a child could go to imminent harm or death? Do you want with your verdict what's coming next to be telling these healthcare providers at the hospital, don't say anything? Because...
Objection, Your Honor. Crossed over to 39.
I'm sorry?
Crossed over to 39.
I sustain that.
Move to strike.
Members of the jury, you're going to disregard the comment about the reporting. The punitive damages are on battery and false imprisonment. That has nothing to do with any sort of dependency court issue.
My point, Your Honor, was not for the call, but for the week where the All Children's was telling the family, we want you to stay, for that week before.
You can make your argument to the jury.
Yes, and for these damages, where you have to find a specific intent to harm, ask yourselves in your heart, do you really believe that these providers who've dedicated their lives to medicine were trying to harm Maya, or do you believe that they were in fear that something bad was going to happen to her? And I would ask you the same with the EEG room and the other categories, because you do have to find that they were literally, not just one of them, but an entire hospital of people who've dedicated their lives to caring for sick children would somehow turn on this child. I don't think you believe that in your hearts. You do not have to award punitive damages. You know that. This form gives you an out to say it's enough. I would remind you that you've awarded $238 million, almost $250 million to the Kowalski family. They are asking you, and $57 million for these categories when I added it up. They're asking you for more. You've heard from Sharon Rogers. It's all going to patient care in your community. It's not a joke, right? And if I'm a little bit cracked up in front of you, because I know every additional dollar that goes out the window, as the judge told you, this isn't insurance. These are real dollars that the hospital is going to have to take from a strategic plan that they have to help children that can't breathe when they're born, that don't have access to cardiac surgery, don't have access to neonatal surgery, don't have access to cure cancer. I would just ask you in your hearts to think, is this really necessary at this point to continue to punish All Children's Hospital? I would ask you to look at the amounts, and I would ask you to ask yourself whether that message is one that you want to continue to send to pediatric providers that have dedicated their lives to medicine, and with a hospital that has corrected errors, undisputed testimony. Let them go forward with their mission to help the sick. Please. Please.
Mr. Anderson.
One thing I think the American people understand is that this size companies always have an argument why they need more money. And I can't believe they're still going after what Beata Kowalski decided to do. They still just don't get it.
Object. Yeah. Withdraw the objection.
Okay. Are you finished with?
I'll say it again. Help them get it.
Do the lawyers wish to examine the evidence before it goes back to the jury room?
Not from the plaintiffs.
No, Your Honor.
Okay. So in a moment, the clerk is going to deposit, and you can go ahead and take both the phase 1 evidence plus the new phase 2 evidence back to the jury room. Here is the verdict form. Jury, you're going to be back in charge of timing, and it's going to be totally up to you for the length of time you wish to deliberate. At some point, if you're deliberating late into the night, I might call it and say you're going to come back on Monday. Okay. But you have the option at your own discretion if you want to keep going or if you want to at some point, just say you all want to go home. So that is going to be up to you within some sort of reasonable hour. Okay. Yes, you can go ahead and take your notes back with you. Yes, you can take the jury instructions with you. The clerk is bringing in the evidence. At this point, may this jury begin to retire or to deliberate?
Yes, Your Honor.
Yes, Your Honor.
Okay, at this time, you can retire and begin your deliberations.
All rise for the second stage.
Our presence, are there other issues that we need to address before we depart and wait for the call of the jury?
On behalf of the plaintiff, Your Honor.
Not from the defense, Your Honor.
And everybody knows we're going to go ahead and reclose the courtroom. So we're going to be in recess at this time, and we will be at the call. Please don't go too far. The clerk has your telephone number, but let's try not to go too far. Okay, we're in recess.
Get a computer system open. Two-factor authentication. Okay, let's see, we've got, is Mr. Shapiro going to be joining us? Okay. I'm sorry? And looks like everyone else is here. This is case number 2018 CA 5321 NC Jack Kowalski, etc. et al. Versus Johns Hopkins All Children's Hospital. I've been advised that there is a verdict in phase 2 for punitive damages. Are there any issues we need to address before we bring in the jury? Okay. Let's bring in the jury.
All rise. Jurors entering.
Okay, please be seated. Members of the jury, I understand that there is a verdict in phase 2 for punitive damages. Is that correct?
Yes.
Let's hand the verdict form to the court deputy, who will hand it to me.
Okay, Madam Clerk, please publish the verdict.
In the 12th Judicial Circuit in and for Sarasota County, Florida, case number 2018 CA 005321NC. Jack Kowalski individually, Jack Kowalski as parent and next friend of MK, a minor, and Jack Kowalski as personal representative of the estate of Beata Kowalski, plaintiffs, versus Johns Hopkins All Children's Hospital Incorporated defendant. Punitive damages verdict form. We, the jury, return the following verdict in regard to punitive damages. Claim 1A, false imprisonment between October 7th and October 13th, 2016, Maya Kowalski. 1. What is the total amount of punitive damages, if any, which you find, by the greater weight of the evidence, should be assessed against Johns Hopkins All Children's Hospital for the false imprisonment of Maya Kowalski occurring between October 7th and October 13th, 2016. $15 million. 2. Do you find by clear and convincing evidence that at the time of the false imprisonment of Maya Kowalski between October 7th and October 13th, 2016, did Johns Hopkins All Children's Hospital have a specific intent to harm Maya Kowalski, and did the conduct of Johns Hopkins All Children's Hospital in fact harm Maya Kowalski? Yes. Claim 1B, false imprisonment between October 18th and October 20th, 2016, Maya Kowalski. 4. What is the total amount of punitive damages, if any, which you find by the greater weight of the evidence should be assessed against Johns Hopkins All Children's Hospital for the false imprisonment of Maya Kowalski occurring between October 18th and October 20th, 2016? $10 million. 5. Do you find by clear and convincing evidence that at the time of the false imprisonment of Maya Kowalski between October 18th and October 20th, 2016, did Johns Hopkins All Children's Hospital have a specific intent to harm Maya Kowalski, and did the conduct of Johns Hopkins All Children's Hospital in fact harm Maya Kowalski? Yes. Claim 1C and Claim 2, false imprisonment and battery, January 6, 2017, Maya Kowalski. 7, what is the total amount of punitive damages, if any, which you find by the greater weight of the evidence should be assessed against Johns Hopkins All Children's Hospital for the false imprisonment and battery of Maya Kowalski occurring on January 6, 2017? 25 million. 8, do you find by clear and convincing evidence that at the time of the false imprisonment and battery of Maya Kowalski occurring on January 6, 2017, did Johns Hopkins All Children's Hospital have a specific intent to harm Maya Kowalski? And did the conduct of Johns Hopkins All Children's Hospital, in fact, harm Maya Kowalski? Yes. So say we all this 9th day of November 2023, four-person.
May I have the verdict form back, please? Do the attorneys wish to examine the verdict form? Do the attorneys wish to have this jury polled?
Yes, sir.
Madam Clerk, please poll the jury.
Juror 93, is this your verdict?
Yes, it is.
Juror 97, is this your verdict?
Yes, it is.
Juror 98, is this your verdict?
Yes, it is.
Juror 19, is this your verdict?
Yes, it is.
Juror 17, is this your verdict?
Yes.
And juror number 1, is this your verdict?
Yes, it is.
Madam Clerk, here's the verdict form. Let's process it and have it become publicly available. Plaintiff's defense, are there any other issues that we need to address with this jury, or may they be discharged?
They may.
May.
Okay. Members of the jury, in a moment, I'm going to give you the official discharge instruction, but let me just take a couple of moments. First, I really appreciate your time and attention over the last 9.5 weeks. I do have a certificate for each of you. I'm going to hand it to Deputy Coley, who will hand it out. And we've given the jury, okay, you have the jury notes? Okay, they have the juror notes. Okay, so if you need to give them to your employers, they'll give you those juror notes. The instruction to not talk about this case will be over. So you will be free to talk about this case or not talk about this case. It's going to be up to each of you whether you wish to preserve your privacy. The lawyers and their agents will not be able to approach you. You, of course, may approach the attorneys, but again, that's going to be up to each of you. At this point in time, I'm going to give you the official discharge instruction. When that occurs, I'm going to have the court deputies escort you out of the building and take you to your cars. So thank you very much for being with us. Members of the jury, on behalf of the parties, the attorneys, and the people of the state of Florida, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years the jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. The attorneys and their representatives are not permitted to initiate any communication with you about the trial. However, you may speak to the attorneys or anyone else about the trial. You also have the right to refuse to speak with anyone. A request may come from those who are simply curious or from those who might seek to find fault with you. And it will be up to each of you to decide whether to preserve your privacy as a juror. And at this point, this is the last time I'm going to say this. You do not have to not talk about this case. You may talk about this case or not talk about this case. You may watch or not watch any news accounts that you may, and you may approach or not approach anyone. So at this point in time, I am discharging you with the court's thanks and the people of the state of Florida for your time and attention. And if you can follow the court deputies. Lieutenant, if I can see you just a second.
All rise. Jurors exited.
Thank you all very much. Please be seated. Are there any issues that we need to address tonight? Okay. At this point in time, we will be in recess. Thank you all for your time and attention. Take care now.